ಮೇಡಮ್ ಆ ಕಡೆ ಅಡ್ವೊಕೇಟ್ ಸಿಗ್ನೇಚರ್ ತಗೊಳಕ್ಕೆ ಹೇಳಿದ್ರಿ, ಅವ್ರಿಗೆ 15ನೇ ತಾರೀಕು ಆಗೋದಿಲ್ವಂತೆ, ಬೇರೆ ಕೊಡ್ಲ ಮೇಡಮ್? 15 ಕೊಟ್ಟಿದ್ದೀರಿ, ಅವ್ರಿಗೆ 15 ಬೇರೆ ಇಲ್ಲೇ ಯಾರೋ ಕೊಡ್ತೀನಿ. ಇಲ್ಲ ಇಲ್ಲ ಮೇಡಮ್, 18 ಬಿಟ್ಟು ಯಾವ್ದಾರು ಒಂದು ಡೇಟು. 18 ಬಿಟ್ಟು ಯಾವ್ದಾರು ಡೇಟ್ ಕೊಡಿ. ಹಾಂ ಆಯ್ತು ಆಯ್ತು. ಹಾಂ ಆಯ್ತು. ಫ್ರೈಡೇ ಹಾಕಿಲ್ಲ? ಹಾಂ ಆಯ್ತು ಮೇಡಮ್. ಸಬ್ಮಿಟ್ ಮಾಡೋದೇನು ಬೇಡಲ್ಲ ಮೇಡಮ್? ಅಲ್ಲಲ್ಲ 15ಕ್ಕೆ ಹಾಕಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ದಾರೆ. ಆಯ್ತು ಆಯ್ತು ಕೊಡಿ. ಓಕೆ
ನಾಳೆ ಆಗ್ಬೋದು.
ಓಕೆ ಓಕೆ ಓಕೆ.
Submission is RFA. Next, okay. Contempt. ಅಲ್ಲಿದೆಯಾ? ಓಕೆ. ಎಕ್ಸ್ಕ್ಯೂಸ್ ಮೀ.
ನಮ್ದು ಅಪೋಸಿಷನ್ ಅವರು ಡೇಟ್ ಕೇಳ್ತಾರೆ ಮೇಡಮ್.
ಮೇಡಮ್ RFAಗಳು ತಗೊಂತೀವಿ.
ಮೇಡಮ್ ಮೇಡಮ್ ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ ಮೇಡಮ್.
ಹಲೋ, ಹೇಳಿ ಹೇಳಿ ಪ್ರಕಾಶ್. ಇನ್ನು ನಾನು ನೋಡ್ಲಿಲ್ಲ. ಇನ್ನೇನ್ ರಿಪ್ಲೈ ವಾಟ್ಸಪ್ ಕಳ್ಸಿದಾರೆ, ಇನ್ನೆಷ್ಟು ನೋಡ್ಬೇಕ್ರಿ ಅದ್ರು, ಏನೇನ್ ಕಳ್ಸಿದಾರೆ ಹೇಳ್ಬಿಡಿ, ಏನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಏನ್ ಕಳ್ಸಿದಾರೆ. ಆಯ್ತು ಆಯ್ತಪ್ಪ. ಎಸ್ ಸರ್.
ನಮಗೆ ಕ್ವಶನ್ ಮಾಡಿದ್ರೆ ಏನ್ ಆನ್ಸರ್ ಮಾಡ್ಬೇಕು?
ಕ್ವಶನ್ ಏನ್ ಮಾಡೋದು ಏನಿಲ್ಲ, ಟೈಮ್ ತಗೊಳ್ಬೇಕು ಅಷ್ಟೇ. ನಿಮ್ಗೆ ಡಾಕ್ಯುಮೆಂಟ್ ಕೇಳ್ತಾ ನನಗೆ ದುಡ್ಡು ಬರಬೇಕು ಅಂತ ಹೇಳಿದ್ದೆ, ನೀವು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡಿದ್ರೆ ಹೆಂಗ್ ಬರ್ತಿದ್ದೆ ನೀನು ಹೇಳಿದ್ರು. ಅರ್ಥ ಆಯ್ತಾನೆ ನಿಮ್ಗೆ?
ಕೊಡ್ತೀವಿ ಸರ್.
ಅಲ್ಲಪ್ಪ, ನಿಮ್ಗೆ ಆಟ ಆಡ್ದಂಗಲ್ಲ.
ಇಲ್ಲ ಸರ್, ನಮ್ಗೆ ಗೊತ್ತಿರ್ಲಿಲ್ಲ.
ಗೊತ್ತಿರ್ಲಿಲ್ಲ, ತಿಳ್ಕೊಳ್ಬೇಕು. ಬೇರೆಲ್ಲ ತಿಳ್ಕೊಳಕ್ಕಾಗಲ್ಲ ನಿಮ್ ಕೈಲಿ. ಸರ್ ಅದು ಹೇಳಿದೆ ಸರ್, ಇದು ಹೇಳಿದೆ ಸರ್, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡದೆ ಇದು ಹೇಳಿದ್ರೆ ಏನ್ 1000 ಹೇಳ್ತೇನೆ, ಕೇಳ್ತಾ ಬರ್ಕೊಳ್ಳೋಣ ನಾನು. ಸರ್
Hello, sir. Hello, sir. I want to join the court number 2. I'm not able to join. Hello, sir. Hello, sir. Hello, sir. Hello. हाँ जी. हेलो हेलो. हाँ हाँ. गुड मॉर्निंग. हाँ वही मेरे को भी जो है ये मैं ज्वाइन ही नहीं कर पा रहा. कोई नहीं, मैं चला जाता हूँ वहाँ, हाईकोर्ट पास ही है मेरे, मैं चला जाता हूँ. हाँ ओके, थैंक यू, थैंक यू.
ಮಾರಪ್ಪ
submission. My lord, one RFA matter, my lord. It was earlier on the final hearing list. Subsequently, because this amendment problem, it was not listed. I request for listing for the next week, my lord. I will serve a copy on the other side and please. Please, ma'am. Please.
Sir, date ಬರ್ಕೊಡ್ತೀವಿ. Sir, 21 ಇಲ್ಲ sir. Roast. For adjournments. Page number 9. Serial number 19 to 22.
Excuse me, madam. My honor, petitioner always take the urgence.
Is she appearing? She's in which matter? Just ask.
ಯಾವ serial number?
1894-22.
Serial number 22. ನಿಮ್ಮ advocate ಇಲ್ವಾ? Advocate ಇದ್ದಾರೆ. 14%.
But they not.
Serial number 22.
Yeah, Satish K. Now what he is asking, just ask her that you have any objection? No, does she have any objection?
Senior citizens.
Then debate. Tell her to call her counsel.
ನಿಮ್ಮ advocate ನ ಕರ್ಕೊಂಡು ಬನ್ನಿ. Page number 10, 23 to 26.
Which number? Yes. Who is the appellant? Have you told the counsel? Then just wait, let the counsel come.
Serial number 1. Lakshita DJ.
So you have to serve respondent 3 and 11 also. Let fresh notice be issued for service on respondent number 3A and B, and also respondent number 11, returnable on.
12-9. Serial number 2. Sri Ravi Kumar BR.
Want to withdraw this?
Name position.
What is this writ appeal number?
My lord, it is pertaining to same matter. It is already pending before the Chief Justice Court. So we'll take all our contention in that matter.
No, we say simply withdraw this.
Much obliged.
The counsel for the appellant has filed a memo for withdrawal. Withdrawal. By stating in the same as under. The counsel for the appellant reiterate the prayer for withdrawal of the appeal. The appeal is dismissed as withdrawn. Just see any IAs are there. And along with IAs are dismissed as withdrawn.
Recurring application is pending.
No. So then recalling application may be dismissed. See, you may be then withdrawing those recalling applications.
My lord, one short date may be given, I'll file an application for that.
No, no.
On submission. I have to respond number one in this case. I have no objection works for the withdrawal of the writ appeal, but however, in respect, so far as they are reserving some liberty, Malaks, to. Could it only be clarified, Malaks, because. Please. In 2009.
2009.
Absolutely. But since the memo is on record, Malaks, it is possible that they may agitate that it is disposed of in terms of the memo. Very well. The appeal was dismissed, there was no condition. Absolutely. The appeal was dismissed, there was no condition for non-prosecution. Absolutely. We have allowed the IA. In IA, he can't say without my right to agitate all the time.
Serial number 3.
For the appellant, my lords, in complaints of a lordship's order, we have filed a synopsis and list of authorities yesterday, my lord. It may be directed to be put up, my lords. We are ready with the matter. It may be passed over.
When passing over may make on submission, we also require to file the synopsis as my briefing counsellor told me that yesterday their synopsis and judgment were circulated to me at 9. Could it be next week, my lord? By that time we will file and argue the matter.
Yes, my lords, I've served it upon.
So yes, we require to file, we will file it within a week. I appeared for one of the staff, private respondents. Also there.
For the others.
R1 to R5 government, madam.
Could I make one more request, you know?
They served in Andhra Pradesh.
I make one more request, you know, to lordship, please. Because one of the contentions I think that the other side is delay and access on that ground distribution capability. Now, my lord, they have produced a material to show some discrepancy in the original record they wanted to encash it. Could your lordship direct the government authorities to get the original record from the land tribunal? According to them, my lord, on case land tribunal. Said 79 order for Thailand in 2000.
2 weeks. 1 to 5 minutes. Two weeks. 2 weeks.
My lords, I request your lordship to fix a date. Much,
5/8, sir. 5/8.
right, much obliged.
Serial number 4, Sri Kiran J.
I appeal for the appellants, my lord. It's for filing of paperwork. I seek for a short accommodation. Two weeks, my lord, I'll file it. Much obliged.
19/8.
Much obliged.
Serial number 5, Shri Ramesh PM.
My lord, I pray for 2 weeks' time to file NOC for on behalf of appellants, my lord. In
One
this-
submission, my lords. In this matter, I represent the respondent number 2, my lords. Have not been served with the appeal memorandum that may directed, my lord. May be directed. Please, my lords.
we will, is NOC we will file, my lord. After that, we'll file the paperwork also, my lord. Yes.
Sir, ನಿಮ್ಮ ಹೆಸರು ಹೇಳಿ sir.
Amarish. Madam, my seniors, I pray for 2 weeks' time, madam. But not Amarish, my seniors, NS But, my lord, NS But. Apologies.
Respondent number 2, my lords. K waiter. Please, my lords. Appeal memorandum has to be served on.
Shri Nagaraj S. Jain for R1. Twenty-two eight.
Much obliged, my lords.
Serial number 6, Shri Leeladhar, HP Leeladhar.
Happy for the appellant. Request for 2 weeks time to furnish the correct address to the respondent number 1, my lord.
And 9.
Ready to file, my lord.
7. Paramrao.
I thought for the appellant, but I have to file LR's applications to bring LRs of the spot number 1 died. They filed a memo, but we did not contain details of the legal representatives. I will ascertain legal representatives of the. My friend is the respondent number 1, my appellant. That's details.
All our brothers sisters, but I now the suit for partition and separate possession. Suit was dismissed. The present appellant.
That's what happens now. They are not speaking terms because their sons, they have to be brought on record, sons and daughters. I will ascertain anyway, 2 weeks. Please,
28-8.
please.
Serial number 8, Shri Vishwajit Rai.
R1 is deceased, your lordship, I'll file application. R1 is deceased, I'll file next the application. Two weeks. Grateful.
Serial number 9, Shri Siddharth Kumar.
My lord, I am appealing for the appellant. I pray for weeks' time to take steps to appellant, respondent 1, my lord.
They were placed ex parte before trial court also, and they were uncontesting defendant. Now they have sold the property to R4. R4 is the only contesting person in this case. I appear for R4. I am the only contesting respondent.
My lord, here the R1 is the erstwhile owner. He fraudulently transferred the property. We would like to take steps. If we dispense their service, we may have problem in future. We will take 3 times and go for publication.
Because I am the purchaser. It is on to buy risk. I will take my entire risk on me. Yes, sir. 2020 matrimonial.
20th August.
Much so, please.
Sir, R3 Ravi. Serial number 10, Sri Siddharth Baburao.
I'm for appellant, my lord.
The course of the year, we will move forward. In the course of the day, we will move from that. The second sit as the file. And another appeals for appealing, I will not press that occasion. Course of the day. So as far as it makes sure, appealing, I will not press that occasion.
Year 1 of 23. Sir.
I will not press it.
My lord. I have filed the paper book and I have served the copy through online, my lord. No. Paper book consisting, serial number 10, my lord. RFA 480 of 20. I was directed to prepare a paper book, my lord. And I have served through online copy. And now I will serve the hard copy.
Yes, sir.
Yes, ma'am.
27A. Serial number 11, Sri Puttegowda.
Please. In this case, my lord, I am representing the appellant, my lord.
For respondent.
Please, may I
I
start?
filed the synopsis in the connected writ appeal 362 of 21, my lord.
Please, my lord. This, in fact, my lord, this matter was heard in part, my lord, and I had completed my submission in the month of February. But because of the change in roster, my lord, therefore again. Please. Please, my lord. Please.
Serial number 12, SPP. KS Anil, Sri KS Anil.
Yes, I am KS Anil.
Appealing for the company. That's me. Company.
Sir, I want to make some submission. So I have difficulty in English language. English language, English submission. I need one translator. So sorry? Yes. ನಾ ಮೆಮೊ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ ಆಲ್ರೆಡಿ ಮೆಮೊ ಫೈಲ್ಡ್ ಆನ್ 11/3 in serial number 20 sir. Serial number 20 same case.
Not in 12, sir.
ಇದರಲ್ಲೂ ಹಾಕಿದ್ದೀನಿ ಇದರಲ್ಲೂ 18/6. $18,600.
ಇಲ್ಲ.
Memo, sir, memo. Sorry? ಅದು ಟ್ರಾನ್ಸ್ಲೇಟರ್ ಒಬ್ರು ಬೇಕು ಅಂತೇಳಿ ಅದು ಯಾರೋ ಮಾಡಿ ಟೈಪಿಸ್ಟ್ ಮಾಡಿಕೊಟ್ಟಿದ್ದು ಅದು ಟೈಪಿಸ್ಟ್. Four, sir.
Four matters. Last year charges was filed, my lord, and it was recalled on the application that we gave. In 12, 13, serial number 12, 13 and 14, my lord.
Yes.
Serial number 2.
Charges might be filed, my lord. Charges might be filed, my lord. No, it was framed and it was recalled on a memo which was filed by the accused, my lord. 36, my lord. Yes, my lord. 36, 2351, my lord. 31st May.
Yes.
Thirty-one five. My lord, emails, my lord. Emails are in annexure, my lord. In serial number 12, my lord. The emails are at annexure A, B, and C, my lord. Page number 13 is annexure A, my lord. In serial number 12, annexure A, my lord, page 13. One three, my lord. In criminal contempt 5, my lord, 5 of 22, which is the 12th matter, serial number 12, my lords.
Yes.
That is at page 13 is annexure A, my lord. Annexure B is also an email which has been sent, and even annexure C. Yes, my lord. Then page number 15, my lord. That is annexure B. That is one more email which has been sent. Annexure C, my lord, which is at page 70, is one more email. My lord. And, no, ma'am. We have not received any copies. Charges recall. 16,600 recall, 16 payment. Charges payment.
ಅದು ನಾನು ಕನ್ನಡದಲ್ಲಿ ಒಂದ್ಸಲ ಫೈಲ್ ಮಾಡಿದ್ದೆ, ಅದು ರಿಟರ್ನ್ ಕೋರ್ಟಲ್ಲಿ ಇದು ರಿಟರ್ನ್. ಎಸ್ ಎಸ್. ಈಗ ಇದರಲ್ಲಿ ಲೀಗಲ್ ಏಡ್ ಬೇಕಂತ ಕೇಳಿದ್ದೀನಿ ನಾನು. ಅದು
ನೋಡಿ.
ಇದೆ ಸರ್, ಇದ್ರಲ್ಲಿ ಇದೆ ಅದ್ರಲ್ಲಿ ಫೈನಲ್ ಇದೆ ಫೈನಲ್ ಇದೆ. ಅದು ಇದ್ರಲ್ಲೂ ಆರ್ಡ್ರು ಆಗಿದೆ ಅದರಲ್ಲಿ. ಇವ್ರು ಕಳ್ಸಿಲ್ಲ, ಹೈಕೋರ್ಟ್ನವ್ರು ಹಿಂಗೆ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. ಈ ಸರ್ಪ್ರೈಸ್ ಎಲ್ಲ ಫ್ರಾಡು, ಇದೆಲ್ಲ ಫ್ರಾಡು. ಆಮೇಲೆ ಇನ್ನೊಂದು, ಈ ಕೋರ್ಟಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಆಗಿದೆ, ಇದನ್ನ ಕಳಿಸಿ ಅಂತನ ಏನೋ ಆರ್ಡರ್ ಆಗಿದೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಇದೇ ಕೋರ್ಟಲ್ಲಿ ಇವರಿದ್ದಾಗ ಆರ್ಡರ್ ಆಗಿದೆ. ಸೆಂಡ್ ಇದು ಟು ಲೀಗಲ್ ಇದಂತನ, ಲೀಗಲ್ ಕ್ಲಿನಿಕ್ ಅಂತಾನೆ ಏನೋ ಇದೆ, ಸಮ್ ಆರ್ಡರ್ ಇದೆ. ಇವ್ರು ಕಳ್ಸಿಲ್ಲ ಇವರು. ಆಮೇಲೆ ಇನ್ನೊಂದು 1ನೇ ತಾರೀಕು 1/4/24 ಒಂದು ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ. ಅದು ಇದು ಏನು ಡಿಸಪಿಯರ್ಡ್, ಈ ಫೈಲಿಂದ ಇದು ಏನು ಫೈಲಲ್ಲೇ ಇಲ್ಲ ಅದು, ಆ ಮೆಮೊ. ನಾನು ಅಲ್ಲಿ ಬಂದು ಸ್ಟಿಚ್ ಮಾಡಿ ಎಲ್ಲ ಕೌಂಟ್ರಲ್ಲಿ ಹಾಕಿದ್ರೆ, ಅಲ್ಲಿ ಕೌಂಟ್ರಲ್ಲಿ ಕ್ಯೂ ನಿಂತ್ಕೊಂಡು ಹಾಕಿದ್ದು. ಅಲ್ಲಿ ಅರ್ಧ ಗಂಟೆ ಬೇಕು ಅಲ್ಲಿ ಒಂದು ಇದು ಫೈಲ್ ಮಾಡಕ್ಕೆ, ಮೆಮೊ ಫೈಲ್ ಮಾಡಕ್ಕೆ. ಅದು ಇಲ್ಲವೇ ಇಲ್ಲ, ಫೈಲಲ್ಲೇ ಇಲ್ಲ. ಇದೆಲ್ಲ ಸುಮ್ಮನೆ ಒಂದು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಹಾಕಿ ನನಗೆ ಹರಾಸ್ಮೆಂಟು. ನನಗೆ VC ಕೇಳಿದರೆ ನೀವು ಕೇಳೋದೇ ಇಲ್ಲ, ಬಾ ಅಂತ ಹೇಳ್ತೀರಾ. ಈ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳ್ತೆ, VC ಹಿಯರಿಂಗ್ ಇಸ್ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ ಅಂತ ಇದೆ. ನಾವು ಹುಷಾರಿಲ್ಲ ಅಂದ್ರೂ ಕೇಳಲ್ಲ, ಡಾಕ್ಯುಮೆಂಟ್ಸು ನೋಡಲ್ಲ. ಇವರು ಫ್ರಾಡು, ಹೈಕೋರ್ಟ್ನವರು ಎಲ್ಲ. ಇದು ಏನು ರಿಜಿಸ್ಟ್ರಿ ಪಕ್ಕಾ ಫ್ರಾಡು. ನನ್ನ ಹತ್ರ ಫುಲ್ ಪ್ರೂಫ್ ಇದೆ, ಎವಿಡೆನ್ಸ್ ಇದೆ. ನಾನು ಅದನ್ನ ಎಫೆಕ್ಟಿವ್ ಸಬ್ಮಿಷನ್ ಮಾಡಬೇಕು. ನನಗೆ ಒಂದು ಟ್ರಾನ್ಸ್ಲೇಟರ್ ಕೊಡಿ ಫಸ್ಟು, ಅಷ್ಟೇ ನನಗೆ. ಆಮೇಲೆ ಇನ್ನೊಂದು, ನಾನು ಹೇಳಿದ್ದು ನಿಮಗೆ ಗೊತ್ತಾಗುತ್ತೆ, ಸಾರಿಗೆ ಗೊತ್ತಾಗಲ್ಲ, ಸಾಹೇಬ್ರಿಗೆ ಗೊತ್ತಾಗಲ್ಲ. ಈಗ ನನಗೆ ಒಂದು ಟ್ರಾನ್ಸ್ಲೇಟರ್ ಬೇಕು ಸರ್ ಅರ್ಜೆಂಟಾಗಿ. ಆಯ್ತು, ಇರ್ಲಿ. ಲೀಗಲ್ ಏಡ್, ಬಿಫೋರ್ ಲೀಗಲ್ ಏಡು ನಾನೊಂದು ಸ್ವಲ್ಪ ಸಬ್ಮಿಷನ್ ಮಾಡೋದಿದೆ. ಸ್ವಲ್ಪ ಹೇಳ್ಬೇಕು ಫ್ಯಾಕ್ಟ್, ಯಾಕಂದ್ರೆ ಫ್ಯಾಕ್ಟ್ ಹೇಳಿ ಆಮೇಲೆ ಅದು ಮಾಡ್ಬೇಕು. ಒಬ್ಬರು ಟ್ರಾನ್ಸ್ಲೇಟರ್ ಕೊಡಿ. ನಾನು ಅದನ್ನ ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 20. ಎಸ್ ಸರ್.
We have put to you that you want to file your submissions on the charge. We want a response on that. You want to file?
ಫೈಲ್ ಮಾಡ್ಬೇಕು. ಎಸ್ ಅದು ನನಗೊಬ್ರು ಫಸ್ಟು ಐ ವಾಂಟ್ ಟು ಮೇಕ್ ಸಬ್ಮಿಷನ್ ಅಂತ ಹೇಳಿದ್ದೆ. ಒಬ್ಬರು ಟ್ರಾನ್ಸ್ಲೇಟರ್, ನೀಡ್ ಒಂದು ಟ್ರಾನ್ಸ್ಲೇಟರ್. ನಾನು ಮೆಮೊ ಹಾಕಿದ್ದೆ, ಸೀರಿಯಲ್ ನಂಬರ್ 20. ಅದನ್ನ ನನ್ನ ಫ್ರೆಂಡು ಅಸಿಸ್ಟಿಂದ ಮಾಡಿದ್ದೀನಿ. ಅವನ ಫ್ರೆಂಡನ್ನ ಕರ್ಕೊಬರ್ಬೇಕಾ? ಅದು ಆ ಥರ ಎಲ್ಲೂ ಇಲ್ಲ, ಯಾವ ಲಾನಲ್ಲೂ ಇಲ್ಲ ಆ ಥರ. ಹೆಲ್ಪ್ ಮಾಡಿದ್ರೆ ಅವ್ರನ್ನೆಲ್ಲ ಕರ್ಕೊಬಂದ್ರೆ. ಅದಕ್ಕೆ ಈಗ ಏನಾಗಿದೆ ಗೊತ್ತಾ, ರೋಡ್ ಟ್ರಾಫಿಕ್ ಆಕ್ಸಿಡೆಂಟ್ ಅಲ್ಲಿ ಡೆತ್ಸ್ ಎಲ್ಲ ಜಾಸ್ತಿ ಆಗ್ತಿದೆ ಗೊತ್ತಾ. ನೀವು ಅವನ್ನ ಇಟ್ಕೊಂಡ್ಬಿಡ್ತೀರ, ಯಾರು ಒಬ್ರು ಸಮಾರಿಟನ್ ಬಂದ್ರೆ ಅವನ್ನ ಇಟ್ಕೊಂಡ್ಬಿಡ್ತೀರ ನೀವು. ಅದಿಲ್ಲ ಸರ್, ಅದು ಮೆಮೊ ಸರ್, ಪ್ಲೀಸ್ ಇದು ಮೆಮೊ. ನಾನು ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 20 ಒಂದು ಡೀಟೇಲ್ ಮೆಮೊ ಹಾಕಿ ನಾನು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸೈಟೇಷನ್ ಒಂದು ಹಾಕಿದ್ದೀನಿ. ನೀವು ನೋಡಿ, ಅದು ಹಂಗೆ ಇದೆ, ಅದು ರೆಕಾರ್ಡಲ್ಲೂ ಬಂದಿಲ್ಲ. ಅದು ಹಾಗೇ ಇದೆ ಅದು. ಆಮೇಲೆ ಇನ್ನೊಂದು, ಎಲ್ಲ ಕೇಸಲ್ಲೂ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇರುತ್ತೆ, ಇವ್ರಿಗೆ ಮಾತ್ರ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ನೇ ಇಲ್ಲ. ಇವರಿಗೆ ಇಲ್ಲ, ಈ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟು ಅಪಾಯಿಂಟ್. ಮಾಡಿ ಸರ್, ಮಾಡಿ ಪ್ಲೀಸ್. ಏನಿಲ್ಲ, ನನಗೆ ಒಬ್ರು ಟ್ರಾನ್ಸ್ಲೇಟರ್ ಕೊಡಿ. ನಾನು ಐ ವಾಂಟ್ ಟು ಮೇಕ್ ಡೀಟೇಲ್ ಇದು ಏನು.
Say so that you don't understand English, you can't take it. Let's be very clear. We still give you that liberty. If you want to bring your friend, you can.
ಇಲ್ಲ, ಅದೆಲ್ಲ ಆಗೋದಿಲ್ಲ. ನಾನು ಬರೋದೇ ಕಷ್ಟ. ನನಗೆ ಹುಷಾರಿಲ್ಲ, ಆದರೂ ಏನೋ ಬಂದಿದ್ದೀನಿ ಭಾಳ ಕಷ್ಟದಲ್ಲಿ. ನೀವು ಹೇಳಿದ್ಕೆ ಬಂದಿದ್ದೀನಿ. ನಾವು VCD ಕೇಳೋದೇ ಇಲ್ಲ, ಅದನ್ನ ಮ್ಯೂಟ್ ಮಾಡ್ತಾರೆ.
Protection of interest depositors act. Protection of interest depositors. Period. 57.
Serial number 20, sir.
20, my lord, is for framing of charges. Yes, ma'am. Serial number 12, 13, 14, and 20. Only 20 is for framing of charges. My lord, 14 also, he had filed a memo last time and the charges filed was recalled. He had filed a memo, my lord. Before charge was framed. In 14 is not for hearing, only 20. My lord, he has not filed a counter affidavit, my lord. As per order dated 15/11/12. And same order, same. This one. Non-filing of written submission, my lord, by the. Yes, my lord, on the charge, as per the order dated 16/6/23. Both, my lord, non-filing of written submission as per the order of 16/6/23. Even on 14. And 20 is for framing of charges, my lord. That is for framing of charges today, my lord. No, my lord, he has not filed. All. Right. My lord, may I make one submission? My lord, my presence might be noted in order. Complaint. Complaint. All the matters. Obliged. Yes.
15, serial number 15. Yatish.
It's a case handler, sir. The jurisdiction.
We are appearing. Your Lordship, we are seeking for the COC, the Committee of Creditors in NCLT. They've sought for to withdraw their CIRP proceedings in the NCLT, Your Lordship. So we have filed the application in the NCLT and it is to be heard. So, Your Lordship, I request Your Lordship to make note of it and it may be heard further upon with respect to subsequent to what will be ordered in the NCLT, Your Lordship. Your Lordship, we have filed the withdrawal application in the NCLT. It is yet to be heard. So, yes, Your Lordships.
In nutshell, if they withdraw those proceedings before NCLT, the proceedings by the competent authority, they may proceed. That's what they are
Your
saying.
Lordship, Your Lordship, we are for Dreams Infra Private Limited with respect to liquidator Mr. Prashant Raju, and we are the IRP 1. And we are concerned only with respect to your Dreams Infra Sumadar project. So rest of the other projects, it can be proceeded, Your Lordship, with respect to this appeal. But the CIRP proceedings, again, the Sumadar project will be withdrawing. No, Your Lordship, it was Dreams Infra as a whole, it was challenged. But we are as a liquidator concerned only with respect to the Sumadar project.
State government, state
Competent
government,
authority.
state government. State government.
No.
6456, myself.
Central government has filed already, my lords. In 290, we have taken a clear-cut stand as per the Supreme Court judgments also. NCLT alone, ICB, under the IBC code, only NCLT alone they have the jurisdiction, no other forum have the jurisdiction in respect of liquidating the companies. That is the stand taken, and also there are judgments which I would like to place on that, my lords. I am representing central government. Central government.
I'm for the state.
No, they are the one who have filed the petition. It's a competent authority appointed by the state government under the act. Yes. Yes, Constance. My stand is clear, matter. NCLT alone has the jurisdiction, not this competent authority or the special court constituted under that act, KPID Act, Karnataka Protection of Investors. The NCLT alone has the jurisdiction in respect of the companies under the IBC, Insolvency Bankruptcy Code. The authority, competent authority, or the special court constituted under the Karnataka Protection of Investor Depositors Act. They are not the, they don't have jurisdiction. There are Supreme Court judgments dealing with the same issues, which I am going to place it.
I have submitted the document in the page numbers. Your Lordship,
My lord,
may
my-
kindly come to petition, my lord, writ appeal 207. I may point out the parties in the writ petition as well, my lord. Writ appeal 207 of 2022, while file. On page number 22, my lord. That is the order which we have challenged before this honorable court. 207, please. Writ appeal 207 of 2022. Your Lordship may kindly come to page number 22. Page number 22, my lord. The parties before the writ petition was the Dreams Infra India Private Limited. They were the petitioners and the respondent was the competent authority. So Dreams India Private Limited challenged the authority of the competent authority to deal with the properties invested in the entire Dreams project. Where criminal miscellaneous 2 of 2020 was pending before the lower special court, that order was challenged before the writ petition. The Honorable Single Bench, my lord, will ordering the order is at page number 42. In page number 42, type page number 21. In page number 42. Yes. The proceedings, para 3, my lord, the proceedings initiated against the petitioners herein in miscellaneous number 2 of 2022 are hereby quashed. So that petition was quashed, my lord. Based on that petition quashed, remaining all other petitions before all the Dreams Infra project, everything got stalled because of this order, stating that the NCLT had the upper hand over the properties when the matter was pending before the NCLT, and KPID Act did not add any authority. That proposition has been challenged before this honorable court, stating that KPID is a special act meant to protect the depositors' investment, and NCLT is a separate scope where it's concerned on the companies and the revealing of the companies. So that aspect has been brought before this court. My lord, I have filed a writ appeal separately, my lord, because I am representing the investors. We are the one who had invested in the Dreams. We are the purchasers. Please, my lord. I am the depositor.
Depositors.
We are the depositors. Ultimately, we have been lost our property, my lord. My stand is a KPD is a special act which has been meant to protect my interest, hence the procedure. Please, my lord. That will prevail over this proceedings, my lord. With respect to company and the company act will prevail. But if they're protecting my interest, KPD is the act which has been specially enacted and special court is formulated. And the competent authority is meant for that purpose.
I have submitted one authority also upon this IA 3 of 23 at page number 70. IA 3 of 23. In this WA 1340, data page 1340.
More submissions, my lord.
I have submitted the authority.
We are not parties.
Yeah. It's on the thing. Number 3 of 23.
In writ appeal, Government of India is not a party. On writ petition, Government of India.
Lord. Let's see. And see page number 74.
The market stuff and innovating.
Number 30.
Innovative. E-judgment.
First, 97 to 130.
WA 134. I'm internal. I'm the erstwhile RP in this case. In this case of Dreams Infra, I am the erstwhile RP, and my CIRP cost is it is under hold, and it is not being paid last 3 years because of this tussle going on. My CIRP cost and fees, which has been fixed by the Honorable NCLT Bangalore bench itself. Number 30.
290, man. WP 290 filed by the state government. Competent authority, yes.
Yes. Yes, my lord. Keep. 1343 writ appeal, my lord. 6456, my lord. 6456 depositors.
In this case, in this case,
He appears.
Yeah. Yes, sir. Today I heard the counter, I filed in the registry. Please.
My lord, in my NCLT appointed RP as a liquidator, and liquidator has not taken any property due to he has not any jurisdiction.
In my case,
In
two
the-
orders have been challenged, my lord. One is moratorium order and another is appointment of liquidator. My case is that both these orders are appealable before NCLAT, that alternate appellate remedy is there. Second is what my learned friend says regarding the
Jurisdiction.
IBC will prevail over the KPID. Yes. Because in a similar act of the Maharashtra, my lord, Supreme Court has held Bombay. Supreme Court has said IBC will prevail.
May I pass on the judgments, my lords?
I've given it, submitted.
Just given. My lord, in my case, kindly see page number 64, my lord. RP appointed by the NCLT, himself given letter to competent authority. He is not able to take position as there no properties, there is no name of the company. In that company, no properties. The accused companies have given many other companies registered. Only competent authority can take all the revenue officers, their powers to take. Justice in my case,
we see
only
what was the
competent
fee as
authority, my lord. My prayer and state government player is same, my lord. This issue is coming from 1 year, my lord. This 207, this. Oh. I mean, we are linked with this file. We are suffering, my lord. Yes, my lord.
I have filed on 7/6/2021 itself. Response was filed on 7/6/2021, my lords. That's a competent authority, state government.
Will file, madam. Will file our response to against that response. Please, copy my last.
One submission. 15.1 is the writ appeal filed by the state government itself, challenging the order.
134.
They have come on record supporting my state. 15.1 is the writ appeal filed by the state government itself.
15.2.
That is 134.
Challenging the single bench order. Please, madam. So they've already challenged that order before this court, 15.1. Please, madam. Please.
Yes, my lord. 1343. 1343.
134.
1343.
1343.
Yes, my lord.
In that appeal, would be a response to the counter affidavit filed by non-government India.
Yes, my lord.
It says so we will report it and then proceed no need for rejoinder. Except the fact that we will give time. We can give time, but we have to give time to remove also the response. So let him file also rejoinder. Yes.
Lordship's kindly, I've made an application for including myself as one of the respondent in 1343 of 21. We are around 400 depositors.
Yes.
We have
Please. We are for the depositors.
we have approached the consumer forum. 400 people, we have approached the consumer forum. We have obtained decree, we have filed execution petitions, attachments have been passed by the consumer forum. Now at this stage, there are two conflicting authorities. One is the NCLT and the government. No minutes, I'm not saying with her.
That's
In my favor.
That's it, not me.
Before the consumer
Correct,
forum.
the lordship is right.
Before the consumer forum. It is
Right,
covered by the judgment of the Lordships of Supreme Court in 2019, SC 838. No, if an order is passed either to NCLT or to the state government, all those decrees. Yes, Millets. Any order passed, Millets, if it doesn't affect the consumer court's order, that is my.
But if you make an attempt to seek execution of those orders.
Yes, Millets, applications are done and the KPID, the special officer, he is obstructing the execution of the system. Saying that I am the authority over this, I cannot execute. Because it is the deputy commissioner who has to execute the orders of the consumer forum. So what he says is there is an order from the KPID. KPID Act is not applicable to all these cases. Why? Because Yes. Protected, my lords.
Your lordship, it's listed for next week, your lordship. It's listed on the next week, your lordship, sir.
One suggestion may make, man. See, now it's only a matter of recovery, my lords. If your lordships think fit, some internal arrangement for recovery purpose. Later, it's a question of distribution, other things may go on because faction.
One submission, my lord. In writ appeal number 207, there is, we have filed this IA number 1 of 2022 for leave to appeal. That may be allowed, my lord. Please.
I appeal first responding. 1 minute.
Yes, my lord. 1 week, my lord.
On 7/6/21.
My lord.
2 weeks, my lord. Interim order may be extended, my lord.
200 depositors have been stuck, my lord. They're all entered hard and money stuck. Mainly the matter will be heard on priority, my lord. Please.
Final date of hearing may be fixed.
Yes, your lordship. Your lordship, we are representing the RP.
Jurisdiction, that's either the competent authority or NCLT.
Please.
Yes.
Absolutely right.
Please.
Last.
In 6456, since I am appearing, name of the Shanti Bhushan may be deleted. Shanti Bhushan, my name is showing. Shanti Bhushan's name may be deleted. Great.
Lordship, may I seek indulgence to place judgments of the Supreme Court so that your Lordship will have the benefit of looking.
Okay, maybe, sir.
In WP number 290 of 21.
Copies of this.
Refer to in the SOB, set of objections. Obliged.
My lord, in WA 1343, interim order may be extended, my lord.
7/11.
Order dated 7/11/2022, my. Please.
I have referred, members. I have referred.
IA 3 of 23.
Myself. Supreme Court. That is Maharashtra.
So my information is not. Yes, sir.
Yes.
5620. So what I have the information.
I think 97 to 1
Yes.
at 1.
Yes, 20.
139.
I have the information.
97.
I will hand it. I'll hand it. Page number 97.
That's actually, I come from Delhi. So it may be second week of August next year.
Yes.
Or third week of August also. Third week of August also. Matter may be posted for final hearing, my lord.
Please, much of, third week of August.
First week or second week, my lord. This is too
This is
late.
urgency.
13th.
Please, grateful.
Thank you, Madam.
Serial number 16.
For the appellants in this matter, my lord, pray for 2 weeks' time, my lord, I shall do the needful.
Seventeen nine.
Much.
Serial number 17. Sridhar.
I pay for the respondent in this case, my lord.
The 240 days filing the appeal. The appellant is placed the expertise before the trial court. Then delays occur.
B.M. Jaydev.
My lord, in this case, my lord, I have filed my objections. The appeal has been filed by the power of attorney, my lord. His power of attorney has already been revoked.
What are you saying?
My lord, in this case, the appellant is represented by his power of attorney holder, Mr. Nagesh. His power of attorney has already been revoked in 2017, my lord. And suit was decreed in 2018. Suit for specific performance. And he has produced a copy of the power of attorney along with the. Okay.
What do you say? What do you say? We can't hear you. Can you be slightly louder, please?
My lord, this appeal has been preferred by a power of attorney holder, Mr. D.M. Nagesh. His power of attorney has already been revoked, my lord.
He is no more the employee.
He is not an employee, my lord.
Present president is the present president is the GPA holder of the society, your lordship.
No, but would he like to come in the proceedings?
Yes,
Because I think what he is saying is Mr. D.M. Nagesh had filed it.
DM Nagesh is the present president of the society, your lord. He is the present president of the society.
He is the president of the society.
Regarding that, I filed additional document.
See, he says that he is the president of the society.
Yes, sir.
My lord, then I'll appear in person, my lord, the next date of hearing. If it permits me, I'll explain, my lord.
Yes. What do you say on delay?
Well, delay, my lord. The suit, sale deed has already been executed, my lord, in this case. Suit for specific performance, sale deed has been executed in 2018, my lord.
No, you have any objection on delay?
Yes, my lord, I'll explain, my lord. I'll appear in person and file my.
Very well. But you filed it. You filed the paper. We'll ask him to file paper books, Mr. Jaydev.
I'll oblige, my lord. But in the meanwhile, my lord, stamp duty has not been paid on the power of attorney. Huge amount of stamp duty will have to be paid on the power of attorney. That document itself needs to be impounded.
We will look into it. But let him file paper books also. But had you taken this objection last time in the?
I filed an application itself, my lord, for impounding of the document.
This was regarding which document?
Yes, my lord. Along with the wakalat, he has produced the power of attorney, Xerox copy. And stamp duty has not been made, my lord. It permits him to execute sale deeds.
This power of attorney in favor of DM Nagesh.
Yes, my lord.
Okay, but have you taken this objection in
Yes,
your
my lord, I filed-
objections?
I mean, I filed an application itself, my lord, for impounding the document. The
What do you
power
say
of
on that?
attorney is in favor of the
Just
president
give a
and the
copy.
executive director, my lord.
Just give a copy of the application to him, to the counsel for the appellant.
I have sent a copy, my lord. I sent it by registered post, my lord.
Yeah, he has filed under 34 of the Stamp Act.
Yes,
Will
my
a
lord.
Copy of the application under section 34 of the Karnataka Stamp Act be given to the counsel appearing for the appellant. Full stop. Mr. Jaydev further states, further request for an adjournment to enable him to appear in the proceedings physically on the next date of hearing. Mr. Re-notify on.
1/8,
Highly obliged, my lord.
1st of August. Serial number 18, Shri Abhishek Yamma.
For the appellant, my lord. My lord, I have a instructions to withdraw the matter. Hence, I seek permission to file the memo before the
Yes,
registry.
you want to withdraw this?
Indeed.
My lord, may I submit?
But there is some other petition pending,
There is a petition pending. And also, his very authority to appear is in doubt here because the appellant herself, if she is directed to be present before the court, my lord, she will say whether she has authorized him to appear in the first place or not. I pointed out in the last date, my lord, even the signature is not her signature.
Signatures are not there.
My lord, one thing is signature. Now thumb impression. There is a DV case pending. In case, she has been directed to be present before the court because her thumb impression is being used over there. Now, under those circumstances, this is, in fact, the court.
Can you keep the appellate present?
My lord, I'm sorry.
Can you keep your party present?
My lord, I am just instructed to withdraw the present matter.
Why should-
And the DV matter is not anyway connected to this matter.
This appeal, how are
My
you-
lord, may I point out, my lord, number one,
You are-
I had said it was infructuous, but they had said at that time it is not infructuous despite the DC's order because there are several prayers which have been rejected by the single judge. Now they want to withdraw it saying it is infructuous.
No, with that in any case, but the only thing is we are more concerned about, the manner in which, more particularly what you are now stating.
Exactly, my lord. That is what I am concerned about also.
But is there any other court is also considering this issue, what you are now agitating?
Not exactly, my lord. The DV case is a little different. There, they have filed a criminal petition also saying direct the DV court to decide these two applications first, which are not subject matter of this appeal. But the whole issue is that at every stage, if really she had given instructions, they would have said, all right, we'll keep her present before the court. The fact that they're refusing to do it shows that there is an abuse of the process of court.
What is her age?
85, ma'am. She completed 85 in June.
What do you say on this submission?
My lord, my only instruction as of now is to withdraw the present
So we need to.
appeal.
They are also not disclosing her location, my lord. It's as serious as.
My lord, 2 weeks time may be granted, my lord. I'll get further.
Who is the
instructions on-
counsel who filed this petition?
Abhishek Yamma, my
Where is he?
he's my senior, my lord. He's in a a different court hall, so.
Just
I'm
call
not
it.
in it, my lord.
Pass over. Right.
Appear for the.
Based on the conclusion, criminal proceedings have been touched.
Yes.
On the last date of
You
hearing.
brought the record.
The 19 records are yet to be received, my lord.
What?
Records are not yet come.
Yes, we had called for the record, no?
Yes, my-
Last
yes,
date.
Yes, my lord, we have intimated, but they have not sent the record. My lord.
The AGA submits, seeks further time. How much time?
2 weeks.
2 weeks to requisition the record as directed by us in the order dated in the order dated 10/6/2024.
I may be permitted to look into the records.
Let it come first.
Yes.
Then surely.
So that I will be in a position to make the submission with reference to the.
Only that the
Limit-
period in
limited per-
between, that's the gap.
Yes.
And the position. Obliged.
29, 7 days. 29. Number 20 adjourned, 21 final hearing. Nagendra Kumar.
Yes.
In this case, my lord, this is
Which is
suit filed by.
Yes.
This is a suit filed by the respondent, my lord, for the relief of specific performance and the alternative relief, if there is a sale deed is not executed, they sought for recovery of money, my lord. Whatever the amount is paid as sale consideration, with interest they have sought for the relief, my lord. The main contention of the appellant is that, my lord, they have not entered into any agreement of sale. Of course, we have admitted the payment which we have received, that is 55 lakhs, my lord. That is the consideration what they have paid. That they see, our contention is that, my lord, we have sought for some hand loan of rupees 55 lakhs because I have taken the loan from Standard Chartered Bank. Wherein, my lord, I have requested them to give a hand loan. I am agreeing to pay some amount as a interest, my lord. That interest was also not been decided. Thereafter, my lord, they have, for the security purpose of that loan, my lord, they have taken some signature on the blank papers, saying that I need some security for giving that loan. The total loan was, my lord, 59 lakhs. After the one-time settlement with the bank, my lord, the bank, Standard Chartered Bank, they agreed to finalize.
Did you repay that loan of the bank?
Yes, that was paid by them.
Directly to the.
Directly to them. That is the amount, the finally one-time settlement, my lord, they have given out of 59 lakh, they have directed me to pay 55 lakhs as a one-time settlement. So I have requested them to pay the amount. They said, I will not give it in hand. We will come to the bank and we will pay that directly. For that, my lord, 55 lakhs directly they have paid to the bank and they have taken the original documents. That is usually, my lord, for the transaction of any hand loan, my lord, the opposite side, that lender who will take the property documents as a security, my lord. They have taken, because if it is agreement of sale, no vendor, my lord, will give the documents, original title deeds to the lender while giving the loan. I mean, while while signing the agreement of sale. Here, they have taken the documents. It was in their custody. Now, my lord, their case is that, my lord, out of 55 lakhs, what we have received, the total, they have mentioned in their agreement of sale that 80 lakhs 25,000, my lord. Now, the dispute is that, my lord, I am agreeing to pay that 55 lakh, but their case is that totally 80 lakh 25,000 has been received by me, wherein, my lord, instead of asking for 55 lakhs, they have demanded to pay 80 lakhs 25,000, or we have to execute the sale deed. That is what the case has been filed before the trial court, my lord. During the time of cross-examination, my lord, in the plaint also, they have not stated, my lord. They have not stated that the 20 lakhs rupees, 25 lakhs, how they have paid it as a cash, my lord. That they totally failed to establish that 55 lakhs we have agreed, but 25 lakhs from where you bought it. No documents has been produced except the agreement of sale. My lord, that exhibit of, that is agreement of sale is also marked as exhibit 6, my lord. They have entered into an agreement with 3 vendors, that is one Shri Harsh Darbar and other 2 vendors are there, the owners of the property. It very clearly established that, my lord, they have not taken the signature of other 2 vendors. Only they have taken the signature of only one vendor, that is Harsh Darbar. Reason is that, my lord, they have agreed to pay that cash amount of rupees 25 lakhs rupees. Once I have also agreed that once I have received the entire 80 lakhs rupees, I will sign along with my mother and brother. They will also sign the documents. They have not taken any signature in the agreement of sale. That agreement of sale only signed by one person, my lord. Therefore, my lord, the respondent, they have later, my lord, they have used the signature by mentioning that it is an agreement of sale and produced before the court with an intention to take the property, scheduled property, my lord. Therefore, my case is that, my lord, I have agreeing to pay that 55 lakhs with interest, my lord, even if they are ready to receive that agreement, I mean, whatever the amount they have paid with interest, my lord, the matter will be settled, my lord. We have, but the court, as trial court, has directed us to pay that entire 80 lakhs 25,000 with 12% of the interest, my lord. Therefore, my humble submission, my lord, in this case, because I don't want to go into the merits of the case, if they are agreeing for any kind of settlement for 6% or 7%, if it is reducing rate of
You have
interest.
to put it to them.
I have already discussed with
That
my
is
learned
between
friend,
both of
and
you.
I couldn't speak to my.
Yes.
Several talks have already happened and failed. As far as
Pardon?
settlement, several talks have already happened and failed. So settlement is no longer a feasible option.
That's the response.
The response is this, my lord. But 20 lakh, even, my lord, 80 lakhs has already been
I think
deposited.
you have to argue on merits then.
Yes, my lord.
Argue.
Yes.
Let's see the issues which were framed and what are the findings.
Yes. The first issues, my lord.
Which
The-
page are the issues?
Issues page
Page 23 of the paper.
23, 24, my lord. May I read, my lord? Whether the plaintiff proves that the first defendant has executed an agreement of sale on 2/11/2006 in respect of the suit scheduled property in favor of him for consideration of a sum of 1,87,50,000. Whether the plaintiff further proves that on the date of agreement of sale, he insisted the first defendant to include the names of the defendant number 2 to 4. The defendant number gave affidavit of defendant number 2 to 4 stating that they have confirmed the right in favor of the defendant number 1. Whether the plaintiff proves that he has paid a sum of rupees 80,25,000 to that first defendant as earnest money. Fourth issue is, my lord, whether the first defendant proved that he was ever ready and willing to perform his part of contract, but defendant 1 to 4 failed to perform their part of contract. Fifth, whether the first defendant proves that the alleged agreement of sale in question was taken by the plaintiff under be enforced. Whether the suit, if property valued and court fee paid, is sufficient, and whether plaintiff is entitled for the relief sought for. The first issue, my lord, with regard to the execution of the agreement of sale, whether they have proved, my lord, the first defendant has executed agreement of sale in respect of the suit scheduled in favor of him for the consideration of rupees 1,87 lakh. My lord, the total amount for the total sale consideration is 1,87 lakh.
There was an agreement to sell.
That is what my case is, that, my lord, the agreement of sale they have taken from the first defendant instead of, my lord, for the agreement for the loan. I'm not interested for selling the property, my lord. I have requested them to, because they came and they said, because we came to know from the other persons, my lord, through some other person, saying that they are lending the money. They are in Mysore, and they said, okay, we will fund for your property. For since I have requested them for some 55 lakh rupees, my lord, that has to be paid to the bank, my lord. Now, my lord, if the agreement of sale is properly entered into between the parties, my lord, there was no difficulty for them to obtain the signature. My lord, kindly see the exhibit P6, my lord. I produced, that is the total parties are, my lord, these vendors, 3 vendors are there, my lord. That is in typed copy I have produced, my lord, in page number 115. In my paper book, my lord. 115.
Exhibit P6 is receipt.
P5, sorry, I'm sorry. 115 page, my lord.
Yes.
Yes, my lord. Agreement is made on this 2nd day of November 2006 between Harsh V. Darbar, that is what the first, the appellant, my lord, here, son of so and so, so and so, which expression so and so and so. Then executed administration. Next, my lord, the Kalpana bin Darbar, first, and Premal Darbar and Snehal Darbar. All the 3, my lord, they have made it as a party, as a confirming witness to this agreement, my lord. In this, my lord, kindly see the original agreement of sale, my lord, that is produced before this honorable court. That copy, my lord, is not legible, my lord. Therefore, it is there in the file, my lord, that is not in the paper book, wherein, my lord, only one person has signed it. That is admitted fact.
Who had signed it?
Only the first vendor. And other 3, my lord, they are not, because here they have made it as a party, as a confirming party to the agreement of sale. Since they have not signed it, my lord, it is clearly established that they have used this blank documents, that is the blank sheet, my lord, the signature who was signed by the defendant has been used as a agreement of sale, my lord. Therefore, my case is that, my lord, I have only requested for, not for the sale. I have only requested for them to give the money to pay to the bank to clear the loans, my lord. That agreement has been used as agreement of sale, wherein, my lord, they have inserted that another 20 lakhs in the agreement of sale, my lord. Kindly see the page, my lord, they have not mentioned the date also when they have made the payment, my lord. In page number 117, my lord. Page number 117, wherein, my lord, the purchaser has paid a sum of 80 lakh 25,000, a sum of rupees 25,000 in cash paid on 31/10/2006.
PCR. Exhibit P5.
My lord, that particular page in the 117, wherein they have mentioned that 25,000 rupees cash that they have mentioned the date, my lord, on 31/10/2006. Next, my lord, 59 lakh 16,551, which they have paid to the Standard Chartered Bank, that is MG Road, Bangalore, that they have mentioned it as, my lord, the 59 lakh 16,551. The balance, my lord, kindly see the balance amount, my lord. That is 20 lakh 83,449 paid in cash to this, to the vendor this day. No date and how they got it, my lord. Even in the cross-examination, they totally fails to establish that from where she got the money and in whose presence that amount is paid. That has been not been established by the plaintiff, my lord.
Yes.
Yes, my lord. Even, my lord, that 20 lakhs 83,449 paid in cash, that is what the dispute in this case, my lord. This amount, my lord, I have disputed that I have not received this money, and for that amount, no interest will be charged, my lord. That is what my request before this honorable court, my lord. And if there is any conditions in the agreement of sale, my lord, the 10% of the interest, if the purchaser, if the vendor purchaser fails to get register the property, 10% amount, my lord, on the advance amount has to be deducted. That is the condition mentioned in. But in their failure, my lord, if the vendor fails to execute the property, my lord, they have not mentioned anything. Therefore, 10% anyhow it is mentioned in the agreement, but the trial court, my lord, directed me to pay 12% of the amount on the advance amount, my lord. That is for the whole total 80 lakhs rupees. Even though I have received the amount of 55 lakhs, it is not a disputed amount, my lord. That is in para 8 of the agreement of sale, my lord.
Let's see the findings, na. Let's see the findings on 1, 3 and 5.
In judgment, my lord.
That's it. Come to page 40.
I got it. That is in para 53, my lord, in the judgment. Admittedly, defendant number 1 has received 80 lakh 25,000 from the plaintiff at the time of agreement of sale, and same is provided by the plaintiff by placing both oral and documentary. Though in his written statement, the defendant number 1 has stated that he has received only 55 lakhs rupees. The plaintiff is entitled for refund of the said money alone. Absolutely, there is no evidence to believe the same. Hence, the court is of the opinion that the plaintiff is entitled for refund of earnest money of rupees 80 lakh 25,000 from the defendant number 1, No doubt there is no agreement regarding payment of interest on the earnest money. However, defendant number one has received huge amount of rupees 80,20,000 but and has failed to execute the sale deed as agreed in the agreement and has retained the amount with him here, thereby causing financial loss to the plaintiff. Under these circumstances, it is necessary to award interest on the earnest money to the plaintiff. Accordingly, I am of the opinion that the plaintiff is awarded earnest money with interest at the rate of 12% from the date of suit till realization.
Yes.
Yes, my lord. Here, the admitted amount, my lord, 80,50,000, I never admitted that 80,25,000. Throughout my case is that, my lord, I have received 59 lakh it is not been disputed by me, my lord.
But what was the total consideration?
Total considered 1,87 lakh, my lord. And out of that, according to them, they have paid 80,25,000. And according to me, my lord, I have only whatever the amount is which they have paid, that is 59 lakh total what we have mentioned in the agreement. Apart from that, my lord, another 20 lakh which they have mentioned, that they have totally in the cross-examination, they fails to establish from where she got the money. And this document has been used it as, my lord, the sale agreement. We have taken only the loan of rupees 59 lakh, my lord. But I have not entered into any agreement of sale with the purchaser, my lord, that is with the plaintiff. Therefore, my humble submission, my lord, as against 59 lakhs, I am ready to pay that amount, my lord, with interest. But even after filing the case also, my lord, even before this honorable court, the 80 lakhs has already been deposited, which was directed by this honorable court. And from there onwards, my lord, since the amount which I have already deposited before, and interest also we cannot be, my lord, continued since the amount on the principal amount which I have deposited, my lord.
Deposited in this court?
Yes, sir. Here 50 lakhs and trial court 30 lakhs, my lord. Totally 80 lakhs. That is 80.
In the appeal, it has been deposited?
Yes, my lord. Even in the execution petition they have filed, wherein I have paid
30 lakhs.
Total is 70 lakhs,
Allah,
50 lakhs
80,
and
80.
20. Order sheet.
Another issue.
I'll produce the documents also.
We
In
don't
the
know.
Huh?
Are we to frame another issue here? on
No,
this?
my lord. I have that because in the execution case,
No, whatever it is, it's part of what is
execution
part.
proceedings order sheet they have not produced. If it is 70, I have no objection, my lord, because whatever it is paid, I have to pay the balance. But principal which was ordered by this honorable court, my lord, that is 80 lakhs. Your lordship has directed me, if the principal amount is 80 lakh, that you have to deposit. Accordingly, we have to, I'll just clarify that whether 70 or 80, my lord. Even yesterday also, I have tried to get that execution or it is there. Yes, it's there. On 2/2/2019, my lord, 10 lakhs has been received by the council for the decree holder. Lokesh, you have received. Just see that whether it is. 20, my lord, which was paid. Therefore, in between, my lord, during the pendency of that, another 10 lakh has been received by the council, my lord, on 2/2/2019. If it is not mentioned in that order, the other.
80 lakhs is correct.
Correct, huh?
Order sheet, very correct.
80.
No, how is the 80 lakhs? 50 here, 20 there.
And 10 before the court is, his submission is recorded in the order sheet. 10 lakhs on
Okay.
2/2/19.
Total-
Additional 70 lakhs was already paid. And additional 10
Paid
lakhs.
or deposited?
80 was deposited, 70 was deposited.
10 is paid to the advocate only.
70 was deposited, 50 here, 20 there,
Please,
and 10 to the,
please.
Counsel on that day was present in trial court, my lord. So totally the principal amount which has been paid, my lord. Even we have disputed the amount for another 25 lakhs is the balance, my lord. That was paid according to the by cash, my lord. That cash, my lord, throughout the evidence, they have not produced any document. In the cross-examination, she has admitted, the witness, that I do not have any documents for from where I got the money, my lord. My entire dispute, my lord, I have
but see the wordings in the agreement.
agreement, it is, yes, my lord.
Vendor acknowledges the receipt of the. No, the balance sum of 2083 paid in cash to the vendor this day.
Yes, my lord. My case is that, my lord, they have filled up later after obtaining the signature, my lord. At their convenience, my lord, they have prepared, because otherwise, my lord, if all the signatures have been taken, my intention, my lord, I have told them specifically that come to the bank, you pay that money. So accordingly, that amount is paid. At that point of time, my lord, they have taken the signature on the blank paper and collected the all originals. My lord, see, collected the originals always in the only if there is any loan transaction, my lord, the property documents will be taken as a security. Otherwise, my lord, and one documents in the stamp paper, they will take the signature. And usually, not only in Bangalore, my lord, if the person fails to pay the amount, they can convert into either in the agreement of sale or any other documents, my lord. Therefore, my case is that, my lord, the loan which I have taken and the signature where I have signed it, my lord. Later, my lord, the understanding was that if you want another balance amount of rupees 25 lakhs, you will have to come to the home and get the signature. By that time, he said, I will hand over that amount and take the signature from your mother and brother and sisters, my lord. Without paying that amount, my lord, this agreement has been filled up. They have prepared at their convenience, and the amount is also, they have mentioned it as a cash and filed it before the trial court for the suit for specific performance, my lord. Otherwise, there was no difficulty for them to take the confirming party's signature on the agreement of sale, my lord. That transaction which was not happened, my lord, that is what my case. Therefore, I am only liable for payment because without collecting the money, my lord, that another 25 lakhs which they have taken it as a cash, my lord, that my case is that, I am not liable for that amount with interest also, my lord. Only the amount which I have received, that is 59 lakhs, what they have stated in their agreement, my lord.
What is the finding of the trial court?
Trial court findings, wherein, my lord, the trial court has stated that we have admitted the amount. Nowhere we have admitted the amount, except that agreement of sale, my lord, I have
No,
accepted
if
that
the-
my
if the-
signature.
If the agreement is proved, then it's an admission that you have received that amount.
Even that agreement is also not proper, my lord. No signatures of other respondents, my lord, other defendants.
But can you disown it? Can you disown it?
Yes, my lord, because
Who is the appellant here?
appellant, my lord.
There is only one appellant, no?
Yes, my lord.
Different. You are defendant number one
I am defendant number one.
and you were contesting.
Your signature is not disputed.
My signature is not better.
But
I have signed the documents.
the agreement is held to be prudent, that amount is paid. And then you are liable. May not be the other.
But agreement where they have made it as a parties, my lord.
See, they have also not come. There is no liability, at least the liability is not being fastened upon them. They have also not come. You have only come. Your sign is there.
Because
But how would non-signing by them would absolve you of your liability?
because they are the confirming party for that agreement of sale, because the property stands in the name of earlier
Very well.
for all the four
If the
members.
confirming party, they will say, look here, how did you sign on our behalf? Or how did you only sign it for this property when we are also the confirming property? You could not have done it. But that will not absolve you. You have signed it.
Because now, if the property, if the order is, judgment is passed for the registration of the execution of the sale deed, my lord, my property would have been under problem, my lord, because if the sale deed is executed, if the sale deed is going to be executed in favor of the plaintiff, my lord, then the very same,
Did anyone appear for them also? For the confirming parties in the suit?
No.
No, my lords, because they have
Were
filed
they,
the
were
written
they served?
statement.
Were they served?
They were served. They're all brothers and sisters.
No, that's what. So no, he's saying, but they don't dispute insofar the agreement is concerned.
The
They don't
reason is
contest.
because I have pleaded that only defendant number 1 is the owner. And because defendant number 1 is the owner, he has admitted in his written statement that he's the absolute owner. So there was no necessity for the other parties to sign at all.
no, then why they have made it as other parties are the confirming parties? Because they have done the agreement of sale. What was the necessity for making their names is also in the agreement of sale, my lord? The reason that they wanted to make it all them as a party and trying to take the property. Then later, my lord, since the agreement was not concluded, because the another amount of rupees, the balance 25 lakhs was required to be paid by them. That was not paid. Therefore, that agreement of sale was not signed by all of the parties, my lord.
Your case for signing the agreement is under duress. That's all.
Yes.
Not that it was taken on
And
scrap paper.
second issue is that, my lord, only the amount which I have received is whatever it is paid to the bank only, my lord. That cash amount they have inserted in the agreement of sale without collecting the signatures of other confirming parties. If I am only the owner of the property, my lord, what was the necessity for making them as a parties in the agreement of sale? There, my lord, the doubt will create, my lord, the suspicious about that, why they have taken that. They are also confirming party to the proceedings, my lord. Therefore, my lord, my humble submission is that even the trial court given the findings that it is admitted fact. Admitted, it's not admitted fact that throughout in my cross-examinations, I never admitted about the another 25 lakhs which they have paid the cash, my lord.
No, that's right. Come to page 58. What the trial court holds is that you admit your signatures.
I'm not disputing even now also.
The signatures are admitted. And what would be the consequence?
Because since on the day of payment to the Standard Chartered Bank, my lord, that is the amount which was directed. Then they said, you first sign the papers here. I will pay that amount. And the signature which I have signed. Otherwise, amount will not be paid to the bank, my lord. Therefore, I have signed and they said, I will come to the house and gave that another 25 lakhs rupees on that day and collected the signature from other confirming parties. Then, my lord, I have, by believing their words, my lord, we have signed because there was an urgency for paying that amount. Others bank would have auctioned the property, my lord. Therefore, immediately I have paid that amount to the bank. And I was not aware that whether this plaintiff is going to fabricate this document as instead of the loan agreement, my lord, he is take it as, the sale agreement for the whole property, my lord. And rest of the things, my lord, other things which I have taken in the cross-examination that I'm not going to establish because there is no order which was passed by the trial court as against the property because it is not a suit converted into finally the recovery, my lord. Property has not been directed to execute in their favor, but only directed them to pay the amount, my lord. But only my issue, my lord, since amount is only with regard to 59 lakh and not other payment which he has paid by the cash.
59 lakh was paid under what agreement? Under which agreement? Under the same agreement?
Same. This is what the signature they have taken. Later they have filled it up.
No, for that, there was no agreement. This agreement is for 80 lakh 25,000. No?
That is what they have taken it as.
7,000 total amount and out of that 80 lakh has been paid under this document. And this is the document which you say that it is the agreement for only 59 lakhs.
Yes, my lord.
There is no other agreement in respect.
No, no, no. They have taken signature on that day and made it as an agreement of sale later, my lord.
They pay to the bank. They pay to the bank, they like pay to the cash. 25,000. Total cumulatively 80 lakhs. He is disputing 20 lakhs. He is disputing 20 lakhs and they pay to the bank. Yes.
May I read the deposition of the cross-examination of the PW1, my lord? Oh, it is there in Kannada, my lord. ಓದ್ಬಿಟ್ಟು.
ಮಾಡಿದ್ರೆ ಏನು ಉಪಯೋಗ?
Again, translation is required for that.
Where is the case setup of duress, undue influence, coercion?
That is my written statement. Therefore, issues has been raised to that regard, my lord. Issues.
My lords, in fact,
That is fifth issue, my lord. Fifth issue is that whether the first email proves that the alleged agreement of sale in question was taken by the plaintiff under coercion, undue influence, and threat, and hence it cannot be enforced.
in fact, at page 86 of the paper book, when he was questioned as to what is the meaning of duress, he says, I'm not aware of what duress means at the last line in his cross-examination.
Which page?
86, my lords. The paper book.
What is this?
The last line, duress, the first word is duress. Duress ಅಂದರೆ ಅದರ ಅರ್ಥ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. It means that he does not know the meaning of duress.
Meaning, that is English word, my lord, that common man, they cannot say that, whether it's, only they will use it as fraud. But duress means that only advocate can say that, my lord. That was, they have questioned to the witness, do you mean that what is the meaning of duress? They should have put it in Kannada. He would have given that.
His cross-examination is only one page, my lord. May I go through it?
There is no translation of it?
No, my lord.
May I be permitted to translate, my lord? Since it's a small portion. Page 85, it commences.
Yes.
The second line says, film production ನಲ್ಲಿ ನನ್ನ ವ್ಯವಹಾರವನ್ನು ನಾನು ಸ್ವತಃ ನೋಡಿಕೊಳ್ಳುತ್ತಿದ್ದೇನೆ. He says he's a film producer and he's been managing the affairs of film production by his own. ವ್ಯವಹಾರ ಜ್ಞಾನ ನನಗೆ ಇದೆ. He says he's aware of business affairs. He has business knowledge. Then from the sixth line, ನಾನು ಯಾವುದೇ ದಾಖಲೆಗೆ ಸಹಿ ಮಾಡಬೇಕಾದರೆ ಮೊದಲು ತಿಳಿಕೊಂಡು ಸಹಿ ಮಾಡುತ್ತೇನೆ. Where he says that without going through the contents of the document, I shall not attest any signature. Next line is, ನಾನು ಯಾವ ವ್ಯವಹಾರ ಮಾಡುತ್ತೇನೆ ಅಂತ ಇರುತ್ತದೆಯೋ ಅದಕ್ಕೆ ಪೂರಕವಾಗಿ ದಾಖಲೆಗೆ ಮಾತ್ರ ಸಹಿ ಮಾಡುತ್ತೇನೆ ಅಂದರೆ ನಿಜ. I put across a question to him saying that upon verification of the documents which are put across to you, only then you sign, for which he says yes. And the last line, my lord.
That is general questions.
Last line
Not
is,
in this case.
ದಾವದ ಅಗ್ರಿಮೆಂಟ್ಗೆ ಕುರಿತಂತೆ ವಾದಿಯ ಮೇಲೆ ನಾನು ಯಾವುದೇ ಕಾನೂನಿನ ಕ್ರಮ ತೆಗೆದುಕೊಂಡಿಲ್ಲ ಎನ್ನುವುದು ನಿಜ. I put across a question, have you initiated any criminal proceedings against the plaintiff for alleging duress? He says, no, I have not taken any criminal proceedings, initiated any criminal proceedings. On the next page, my lord, the second paragraph, about fifth line, Davada agreement Vyavahara.
This is the only document, there is no translation or other documents are there?
Other
The cross-examination-
PW1 cross-examination
Only
Only
is
this-
also translation.
The deposition must have translation.
Yes. That was long back it was filed.
Apart from this, the further cross-examination is in English.
I think a few pages are there, you can get it done in a week.
Few pages for deposition of PW1, there are totally 4 witnesses, they have given the
The
evidence.
learned judge relies upon these deposition. His conclusion is based on these.
Yes, my lord. In page number 41, my lord, in her cross-examination, that is the PW1 cross-examination, I have put a question, my lord, with regard to that. What is the proof that you have? May I read that in first?
What
In
is this
Kannada?
page 71, 72, 73, 75?
That is also other witnesses who have given evidence and cross-examination.
Those are all in furtherance of specific performance.
They are
We
the
not seeking
witnesses.
Then
specific
see 84, 85.
84 to 87 is the cross-examination of defendant number 1.
There is
Further
no
cross-ex-
translation, huh?
There is no translation
Then you file the translation.
Translation.
of the deposition.
I'll
Fine,
find
you
it.
will file it.
I'll find it.
Just take down.
It starts from 37 to 100, my lord.
During
Total.
the course of hearing, it is
No,
noted.
Not complete. Chief is, I think, affidavit is in English.
Ah.
Only the cross-examination portion of the witnesses is in Kannada.
So
Those
that is, I
pages-
think it's only defendant number 1 and the plaintiff is, I think, enough because other rest of the,
No, you file everything.
everything. Obliged.
For all.
I'll file it.
We find that the paper book consists of certain documents in Kannada which have not been translated. The learned counsel for the appellant seeks 2 weeks to file the English translation of those documents. Just re-notify after 2 weeks.
It's only a deposition. my lord. Deposition, not other.
No, you file everything.
I
See,
mean,
then it transpired that you require translation for them also. Better you file it.
ಅದು ಬೇರೆ ಕನ್ನಡದ್ದು some other documents maybe it's I'll see that my lord. Any documents if it is
Other documents are there, which are there?
Only deposition.
some khata and other documents it's there in I'll produce it. I'll file it. 6 8 much of it.
Till number 22, Shishan Mukappa.
For
Are you-
appellants, my lords.
Respondents.
2 weeks time, my lords.
Why?
That's my senior is not well, my lords. And we engaged.
My lords, there is an urgency in the matter. Respondent is really old. Kindly pass over the matter. Senior counsel is engaged in this case.
Lads, we also engage senior counsel, my lord, but he is also not in the station, my lords. Kindly accommodate short, my lords. So next week, my lords, we'll argue the matter.
See, there are documents which are in Kannada
Please, my lord.
that need to be filed, translation need to be filed there.
Nearly 200 documents are there, my lords. We
Pardon?
need time. Nearly 200 exhibits are there, my lords.
These pages are coming.
My lords, short accommodation as there is an urgency in the matter. The respondent is
Even
really.
you file, no problem. But translation should be there, no? Lot of documents are there.
Will you file it?
I'll file it, my lords. It'll take time, my lords.
Because we find that the paper book filed by the appellant herein consists of documents which are in Kannada. The English translation of the said document shall be filed within 2 weeks.
Number of documents are there, my lords. 4 weeks, my lords. Please.
2 weeks. After 2 weeks.
Please.
22/8.
Oblige.
Yes. 23.
For ejectment.
Appellant by me. Suit for possession, damages, arrears of rent and compensation. The basic facts are in nutshell.
Well, before my senior friend could commence, my lord, I'll make one submission in this matter. No, he has no locus standi to file an appeal, my lord. That's on this ground itself, it has to go. That's the reason. Because he's not a tenant, he's a subtenant. On this ground alone, my lord, his appeal has to be dismissed.
But he was a party before this in the suit.
Please.
You made him a party.
He was, yes, ma'am, he was a party. He was a party.
If he has no locus standi, why did you make him a party?
Because he was a subtenant, my lord.
Correct. Why did you make a party?
He was in position under.
Then, because you made him a party, he is in appeal before this court.
But the tenant has not come.
No, madam. He has.
I and tenant are selling together. The facts are that prior to 2000, both respondent number 4 and I were carrying the business in the premises. Owner made an offer saying that you put up in construction on your own expenses. After putting up construction, occupy ground and first floor, second floor to give it to him, and thereafter we'll enter into a fresh lease agreement with us, fixing the nominal rent. This was an agreement which was executed on 12/11/2000. The agreement was taken in the name of respondent number 4. Taking advantage of that fact, he is saying that I am not a party to that agreement. Therefore, he is refused to recognize me as a tenant. And my case is also that I and respondent number 4 are not tenants under the respondent number 1. Therefore, he cannot file a suit for ejectment. May I take your attention to the necessary pleadings available.
Admittedly, this agreement is not before this court.
If you want to address argument, let him address. I will address it subsequently. Interfering in between is. ಇದರಲ್ಲೂ ಕನ್ನಡ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದ್ದಾವೆ. Cross examination in Kannada. I will file translation.
You file it. It would be appropriate. Translation must be here on record. And must be relying upon those also.
Yes.
Same order, just make the same order. Give a different date.
28/8. Twenty-four. Narayan's one.
my lord, in this matter.
My lords, we have engaged senior counsel in this matter, so press time. August. Mr. Vikram.
My lord,
Yes.
may I make one submission, my lord? In this matter, my lord, previous date of hearing, my lord, Senior Counsel, Mr. DLN Rao is appeared and made a submission. The previous date, the matter is listed in second list and posted for first list. And other side counsel is not appeared on that day. Therefore, it's listed before this court on first list only, my lord. May I request to kindly pass over?
Will pass over.
Please.
$25.
Then I.
Yes.
But brief is made so that we certain government lands were brought for auction under the Karnataka land grant rules. I was the successful bidder and government confirmed the auction in my favor. Then this certificate of sale was also executed. Since I was a company, I am a developer, members. I requested before handing over possession to me, have the land converted for non-agricultural residential use. That was also done. Sale certificate was issued. When I go to the register the sale, the certificate of sale, sub-registrar says this has been acquired for Bangalore Development Authority long years ago. Then, my lords, I moved the government, I moved the deputy commissioner that you brought the land for sale, and then you on my behalf you applied for conversion. Even while seeking conversion, one of the requirements is that no objection from the BDA should be obtained. You have obtained no objection from the BDA and then converted the land for residential use. While issuing NOC, the BDA has specifically stated that this land is not subject matter of acquisition. This land falls under the residential zone in accordance with the revised master plan. Therefore, conversion can be ordered. After all this, then when this came up, I wrote to the deputy commissioner that please have the land deleted from acquisition, because even according to the admitted case of the BDA, possession was taken by them in the year 2000, that is, my lords, that is in the year 2014, as depicted in their statement of objections. Whereas land has already been delivered to me on 17/10/2008. Then, my lords, proposal was made to the government to delete it from acquisition. Then, my lords, what happened was the state government said, you suggest an alternate land. They rejected the proposal for. Then I came before this honorable court and filed the writ petition. In the writ petition, what happened was, my lords, there were large number of writ petitions in the matter of Arkavati layout, acquisition to Arkavati layout. All the writ petitions were clubbed, even though those were all individual grievances where the individual prayers for either allotment of an alternate site or something like that had not happened. And their principal grievance was that while considering the cases for denotification or allotment of alternate sites, guidelines framed by the Supreme Court in Bundu Ramaswamy's case had not been followed. What the learned single judge does is, my lords, he appoints a high power committee is appointed, headed by a retired judge of this honorable court. All those such cases, including mine, is referred to the, because though my case entirely stands on a different footing. Then what is during the course of hearing of this writ petition, my lords, saying that it may not be, it may take another decade for me to get the land. On 16th March 2023, if my lords would kindly see the order sheet, my lords. A submission was made on behalf of the appellant that I have brought this land in public auction for a valuable consideration of 4 crore 60 lakhs. If the government would return that, if the deputy commissioner and the government, if they refund me that money along with reasonable interest, my grievance would be redressed. Because my lords, already my money is with the government for the last 17 years, the money is with them. I don't see any chance of any alternate land being given to me for the next another 2 decades. Then once I am a developer, my funds are held up, my lords, and all that I am now restricting is that let them refund that amount with a reasonable amount of interest. At that stage, my lords, the government advocate took time to obtain instructions. That is now, my lords, it has come. This was March 2023, they took time for that. Now we are in.
What the instruction they had?
I don't know.
I pay for BD in the
A week's time we return to my lord.
For what?
Our instructions, my lord. Next week.
See, the time was given, and what is the
Yeah, changes in
submission
officers,
made is whatever amount he has deposited, that should be refunded.
A week's time we return. Next week, any date may be fixed.
When was the matter listed last?
Last, my lords, last it came up on 24th March 2023.
So that's the only time. It's been 1 year.
Yes, ma'am.
But did you, after that order, did you ask them what are their instructions?
The officers are changed, my lord. The officers are changed from the department.
I'm giving you 63 days.
See, 16.3 ನಲ್ಲಿ it was specifically noted, you have to come back on this point. 16/3/2023.
Yes, my lord.
There is a specific order.
Seek instructions.
In case the state government decides to refund the amount deposited by the appellant along with the interest, the grievance of the appellant would stand redressed. In view of the above submission, B. Rajendra Prasad, learned High Court government leader, praised for an adjournment to enable him to seek instructions. So it is 1 year. You are not sought for instructions.
Finally, a week may be fixed.
On 16/3/2023, the learner senior counsel appearing for the petitioner appellant has drawn our attention to order dated 16/3/2023, which reads as under. What is the interim order passed?
No interim order in
The
this.
interim order, my lords, was directing BDA not to create any third-party interest over that land.
What is the date of that order?
My lords, it is 7th of November 2022, if I'm not wrong, my lords. Sorry, I did not kept the order copy with me as of today.
Was there any interim order at all?
That is the direction given.
There was an
7th of
interim order, my lords, that on the land in question, the BDA should not create third party.
Third-party interest was requested, my lords. That's the direction which has been issued by the honorable court.
Now that entire Arkavati layout itself has run its, no, lords, for the first time, after referring of my petition, my prayer to the committee, I have now received a notice that on 23rd August you appear. But it is.
What is the date you said order? Shall not create. That's
Please.
23/1/20.
I'm sorry, my lords.
23/1/23.
23, please. I refer to the.
For the following, the learned it is noted that the counsel appearing for the which respondent?
There's more
State, my lord. State is-
Responding for the state government of for the
Respondent.
respondent.
3.
Sought an adjournment to enable him to seek instructions.
Please.
It's stop. The respondents, today the learner counsel appearing for the respondent number 1, 2, 3, and 5.
Yes,
That's-
sir.
No,
that's
5 is
five
your-
is also represented, Mills.
and
It's
three.
part of BDM, Mills.
1, 2, and 3.
1, 2, and 3.
Seeks further time to take instructions. Full stop. BDA has no concern insofar as this is concerned.
Well, that's the
On the
money
refund.
money has been remitted to the state, my lord. So the state would have to refund this.
I purchased an auction conducted by the deputy commissioner and amount has gone to the treasury,
Full stop.
not to the BD.
Governor, noting the said submission, how much time?
2 weeks.
After 2 weeks, just after 2 weeks, this listed. Interim order dated so and so shall interim order, if any, to continue till the next date of hearing.
Please.
Yes.
23/1/2023.
No,
Shall
not
continue.
this next date of here.
Pardon?
Great.
Date we are giving you.
Please. Great.
In this case, Lord,
Appellants.
in this case, Lord,
This is a,
my respectful submission is earlier, my Lord, but my senior counsel Udayawalla, my senior has appeared. Therefore, my Lord, he has got inconvenience today. Can it be on 23rd or 24th, my Lord, as we will argue? Since, my Lord, that, not that, my Lord, in this appeal, entire amount has been paid by us.
Sure, be fine.
if I may, madam, in a nutshell. The facts of the case, my lord, the respondent is a borrower of which availed loan from the appellant. The respondent became NPA, subsequent to which, my lord, the respondent made a proposal of OTS. Now, as far as the OTS amount is considered, my lord, the OTS amount came to be rejected by the appellant. Being aggrieved by this order, my lord, the appellant since 2011, my lord, made many petitions before this honorable court, my lord. The first petition happened to where there was a direction given to the appellant to receive the amount which is there. But however, we had not accepted the OTS amount. In the same manner, my lord, one more petition was filed. Eventually, my lord, what happened here is the actual so-called OTS amount, 70% of the amount was paid where I had not agreed to it because there was a direction of the court, this honorable court. The impugn order as on today, my lord, goes on the pretext to say that the impugn order came to be passed because the valuation as per my report is higher than the amount what is mentioned here, my lord. On that reason, my lord, the OTS was rejected. Being aggrieved by that impugn order, my lord, they came before this court. The court goes ahead and passes an order saying that since it's an educational institution, priority has to be given to the education of the children and not otherwise. Considering the fact that they have already accepted 70% of the money, there's nothing more to be looked into. Be that as it may, my lord, the court goes further and closes the DRT proceedings, the 138 proceedings, all other subsequent proceedings, and where other statutory act I am obligated to initiate, which I have initiated. My grievance today, my lord, there is a DRT matter which is posted for judgment. Now that is kept in abeyance in view of this order.
Can I make
In
one
fact,
submission?
if I may, my lord,
Can I make one
this
submission?
particular impugn order, my lord, is against the principles of the Honorable Supreme Court of India, my lord. It's clearly laid as far as the OTS amount is concerned. A financial bank order should not be interfered.
My lord, can I make submission, my lord? That, my lord, on 7/2011, that they have requested me to pay 3 crores as against, my lord, 1582, so that they will give, my lord, OTS. Subsequent to that, on 15/7/2011, they have issued OTS letter. On 15/7/2011, they have arrived at a conclusion of 11.74 lakhs, my lord. Ultimate as against 1582. Subsequent to that, my lord, as against 1174 crores, they have directed me to deposit 5 crores, 10% of the due amount. And ultimately, my lord, I have deposited 58 lakhs. And thereafter, my lord, that they have not taken decision. Ultimately, I have approached this honorable court, and this honorable court directed to pay them through this court only. In this court, by virtue of an order, we have paid entire 11 crore, 33 lakhs and 58 lakhs. 58 lakhs during the pendency of the writ petition, they have returned. And ultimately court told that with all, my lord, recommendation, my lord, the OTS has been granted. Ultimately, after payment of this amount and earlier payment of 3 crores received, they have rejected, which is considered by the learned single judge, saying that this is an education institution and they have genuinely paid the amount. And as against 1582, we have paid 1682 crores by the whatever they have claimed. Therefore, my lord, court hold that, my lord, that whatever 1174 crores is, my lord, that is accepted. That is which is challenged before this honorable court. My sincere request is, my lord, that we will argue on merits all this case. Therefore, my senior engaged already. Therefore, my request on 20
Start, we'll hear it.
or
Join in.
23rd
My
or
lord, I
24th,
may
we will
be-
finish it up.
My only request.
Because, my lord, this, they have initiated DRT case. They have initiated 138, 16 cases has been filed. And thereafterwards, my lord, everything has been, my lord, since, my lord, we have paid entire amount what they have demanded. Therefore, on 23rd or 24th, my lord, we will argue on the same day. Senior will also be there.
We can hear him start, let him start.
Please.
Please.
Yes.
The respondent has filed a memo wherein the impugn order, there were some clerical errors, my lord, which were rectified. That memo, if I may refer to the impugn order.
Dates.
6/12/2023. The impact 6/12/2023, my lord, the respondent filed the clarified impugn order. Some copy served ಮಾಡಿದ್ರು this only. Anyway, I have another set of it, my lord, I'll have it.
Yes, yes, it is there. Delay.
My lords, have. If I may read the impugn order.
Yes.
Please. The impugn order, my lord, as far as the impugn order is concerned, my lord, the only reason given for interfering as far as the OTS rejection is concerned, my lord, at para D at ink page 7, my lord.
Paragraph?
D at ink page 7 of the impugn order.
Yes.
The opinion of the respondent that the market value of the security intent is much higher, again, is defective. In fact, the Shri H.T. Vasudev, who has happened to be the chartered engineer and government approved valuer, has worked out the distress value of the mortgage property at 14 crores 36 lakhs 18,727 with a little, which is a little less than the outstanding amount of 15 crores 84 lakhs 21,000, my lord. This amount, which is reflecting as 14 crores odd amount, my lord, does not reflect in the valuation report given by the respondent, my lord. In fact, it shows clearly that is much higher, my lord. It goes up to 23 odd, my lord.
The outstanding was 15 crores.
Please, my lord. As on that date, my lord. My lords may have it at the volume 2 at page 509. In fact, the valuation report is not by the said person, it is by somebody else called Boraya.
Which page is that?
509, volume 2. My lords have it. Para number, in the table, my lord, serial number 4.
Now, whose valuation is this?
This is by my valuation.
Your valuation.
Please.
And how did that figure came? 11 crores or 14 crores?
No, that's, we are not sure, my lord. I'll, with all due respect, my lord, this is an NOC matter given to me, my lord, but I in fact went through.
What is the matter?
This is a matter given, the trial, the single bench, what is argued by another advocate, my lord. I have gone through the order, the documents, my lord. This particular amount doesn't reflect, my lord, unless my learned friend may correct me.
Where is the valuation here?
At serial number 4, my lord, distress value is 29 crores 76 lakhs 99,000.
These are the values of the assets.
Please, my lord.
Which have been mortgaged.
Please. Now, being so, my lord, this particular amount, we are not unclear as to, on this particular reason, that this amount is closer to the amount which is mentioned as the outstanding amount, in view of the fact that the substantial amount has already paid by the respondent, there is nothing more to be considered, my lord. The only moot point here is regarding this, my lord. While such a situation, my lord, it is this decision ought to have been left to the decision of the appellant herein, my lord. The Honorable Supreme Court, my lord, has held, as on last year, my lord. The situation here, my lord, 1 month before this order was passed, my lord, on December 15, 2021, the Honorable Supreme Court passed an order which clearly stated, as far as an OTS amount is concerned, my lord, rejection or allowing cannot be challenged before any court, because that should be left to the commercial wisdom of the court. Now, that particular decision, my lord, or rather this impugned order completely goes against the principles of that order, my lord. Now, even assuming that this amount was wrong, my lord, the prayer of the respondent is not to close the proceedings, my lord. The prayer was only limited to the fact that to direct the appellant herein to collect the OTS. Assuming that had been done, it was my duty to go to the DRT and close the proceedings, my lord, assuming. But however, my lord, when the order itself is not there, but the prayer itself is not there, my lord, the single bench order goes beyond the prayer, my lord. In fact, the Supreme Court has already said that, my lord.
DRT proceedings are pending and
Yes, my lord, it's posted for judgment. It's posted on September 17th, my lord.
in fact, reserved for orders.
Reserved for, in fact, it's posted on the 5th of this month, my lord. Now it's again adjourned.
See the date?
17th of September. 17th of September, my lord.
The next date.
Please, my lord.
Which DRT?
DRT 2, Bangalore. Now, considering the fact that the value is higher, my lord, I am entitled to recover more amount. Now, on the threshold of me directed to...
That you say you can recover through the...
Whether I recover it or not, my lord, under the DRT, the remedy is available for me to go through that manner, my lord. In execution, whether I recover it or not, of course, it's a subjective question. But my right to exhaust, that remedy is still there.
When did you initiate DRT proceedings?
No, that is... on 12/3/2009, man.
12/3?
2009. Much earlier to the OTS proposal.
And when was the first litigation filed by the respondent here?
24/3/2010, my lord.
That's the first petition.
Please, my lord.
For what?
For a direction to asking the appellant here in my lord to accept reclose. The list of dates, my lord, at page 6 of the list of dates, my lord. In those sequence, it goes. So while my DRT proceedings was pending, my lord, they have given an OTS proposal. I am bound by my regulations as how the manner in which I'm supposed to accept the OTS. I have made a decision to that angle. Now, being aggrieved by that order, my lord, they have come before the learned single judge. If this is entertained, my lord, tomorrow.
This is the only ground you are seeking?
Please, my lord. So for the fact that as far as my OTS amount is concerned, it cannot be interfered. It is my legitimate reason as to why it has been
Let's
done.
read this judgment.
Please, my lord. My lord, ink page 10, my lord, para 11. This is a judgment, my lord, where Honorable Justice Shah and Justice Nagaratna had passed the authority, my lord, wherein it was considered with regarding to an OTS amount, whether it can be rejected or not, can a court look into it to that extent, my lord. Now at ink page 10, my lord, para 11, if I may read, my lord. While passing the impugned judgment and the order, the High Court, in response to the submissions of on behalf of the bank, there are all possibility for recovery of the loan amount, and the efforts are being made to recover the amount by initiating proceedings under Sarfazi Act, and the property's mortgage can be auctioned, as observed that the proceedings under the Sarfazi Act have remained pending for 7 years, and the bank has been unable to recover this dues, and therefore the hope of recovery is illusionary. This conclusion is not supported by any material on record. Merely because the proceedings under Sarfazi Act have remained pending for 7 years, the bank cannot be held responsible for the same. No doubt the bank can be found. Next, this following lines are important. What is required to be considered is a conscious decision of the bank that the bank will be able to recover the entire loan amount by auctioning the mortgage property, and the due application of mind by the bank that there are all possibilities to recover the entire loan amount. Instead of granting the benefit under the OTS scheme to recover a lesser amount, it is ultimately for the bank to take a conscious decision on its own interest and to secure the recovery of the outstanding debt. No bank can be compelled to accept a lesser amount under the OTS scheme, despite the fact that the bank is able to recover the entire loan amount by auctioning the secured property mortgage property. When the loan is disbursed by the bank and the outstanding amount is due and payable to the bank, it will always take a conscious decision in the interest of the bank and its commercial wisdom, my lord. I am on this, my lord. Whether it is the fact remains that the OTS amount has been rejected. There's a DRT proceedings pending. They have a right to object in whatever way possible, my lord. On the disguise of being forced to accept this money. Yes, my lord, I have not challenged that order, be that as it may, my lord. But
which order?
The subsequent, the earlier orders which direct me to accept the money. Those amounts were accepted without prejudice.
Where are those orders?
No, they have also been produced. They have only to accept the amounts which have been over a period of time. If my lords may recollect, my lord, I said that over a period of time, my lord, close to 70% of the amount have been paid in view of these orders. And then now they claim that since 70% of the amount has already been taken by you.
So this is the first time they made a claim and 70% has been made. This would suffice the requirement.
Correct. And since you have accepted 70%, my lord, the learned.
What were the previous litigations?
The same OTS were given, my lord. Then I rejected the OTS, and then thereafter I was directed to accept the money, my lord, and the same manner it went through, my lord. And the same manner, the single bench order also came to be passed. The only difference here was.
Where are those orders?
The orders are here. First order, my lord, is at page 360. In fact, the impugned order narrates as to how I have received these amounts. My lord, if I may request my lords to see the impugned order in page 3, my lord. that narrates all the proceedings which has been initiated.
Okay. When do you
Now-
want?
Kindly see for a moment.
Yes. Yes, anything else?
Well, there one more judgment, my lord, where the Honorable Supreme Court goes on to pass, as far as an educational institution is concerned, my lord, no special treatment has to be given. Specifically with regarding to Maharaja. Interestingly, my lord, the appellant herein is the respondent in this case.
This was against you.
No, my lord, in fact, it was in favor of me.
Which paragraph?
May I, my lord, please turn to ink page 14, my lord, at paragraph 14. The context of how an educational institution should not be a special treatment has been looked into, my lord. If I may, my lord. The educational trust is running various institutions, hospitals, but at the same time is not making payments of dues of loan amounts to HUDCO, by which it is established which is established by them. DRAT in its order dated so and so is in appeal so and so, so and so. So then, my lord, may I kindly turn to para 20, my lord. It is apparent from the avowments made by the trust itself that it has more than 700 employees and 3,000 students are taking education, but it is shocking and surprising that the amount due to HUDCO has taken as loan in 1995 is not being paid, which has assumed to approximately 480 crores at present. It is also apparent that there are several rounds of litigation in spite of the order of the DRAT with respect of the loan amount having attained finality. In my case, that it has not been attained finality because the DRT matter is posted for judgment. Is not attained finality, is not being honored for recovery, which proceedings under the Surface Act had been initiated by HUDCO for any other result. The history of the case projected clearly indicates that it is virtually impossible to realize the dues owing to various litigation pending and filed by parties or some other parties. Now, my lord, may kindly turn to page paragraph 40 at ink page 22. Please. In the instant case, it is apparent that the educational institution is a willful defaulter and has built the property, colleges, hospitals from the money borrowed from HUDCO. It was the burden duty of the educational institution to pay back the money to HUDCO. Thus, no equitable principle comes to their rescue as despite running the educational institution for more than 22 years. In my case, my lord, they have run the institution for more than 10 years, man. In fact, more than 12 years. They have not paid back the money. Once they want to run their college, hospitals, etc., built up with the help of the money advanced by HUDCO, obviously they must honestly owes out the advantage which they have derived from the institution. But it has become a general scenario that persons who earn money with the help of hefty loans, in spite of running institutions which have been set up by the money lent by them, they are not making payments of dues. So consequently, they will have no right to run the educational institution in such a dishonest manner. The increase of non-performing assets in banks is one of the offshoots of such murky deals. It is shocking that despite having means of earning profits, they are not interested in making payments. Time has come when they have to be dealt with sturdily and from the iron hand, as so as to make them pay public dues. Now, this context, my lord, even the further lines clearly goes to show, my lord, why educational institutions should not be given any payment. The learned single judge predominantly goes to the fact that since this is an educational institution, states are not in the do not have the bandwidth to provide education. Such a support has to be given.
What are the orders passed in this appeal? No orders on the deposit.
No. I mean, there are subsequent saying I need to accept the money and then the remaining balance, my lord.
What do you say?
My lord, the impugn order, my lord. The
No,
impugn
no. In this, there is no order of deposit in the appeals.
But however, my lord, the conduct of the
We
education.
voluntarily went and given
No, no,
the
sir.
DD, but they have refused.
They have not accepted.
Not accepted. I have produced that.
Because I have filed the writ appeal. Yes.
When do you want? Matter.
On 23rd.
20?
Third,
23rd.
yes.
Have it on, we have heard the counsel for the appellant to come up for the arguments on behalf of the respondents, 23rd.
Yes.
Okay.
Insofar as that Vasudev report is concerned, my lord, there are 3 reports are that we have produced. Yes.
Hear you, didn't hear you.
Please, please. If at all they are accepting remaining amount also, we are ready to pay once again. Much obliged.
Grateful.
So,
First door matters. Bill number 11. Devagoda.
just an overview of the matter.
Lord, this is, please,
What is the overview?
this is the case, my lord, pertaining to dispute of promotion from the post of assistant engineer to assistant executive engineer, my lord, AE to AEE, my lord. I am appellants, Lord, I am representing appellants, my lord. They are direct recruit graduate assistant engineers, my lord. And the private respondents are, my lord, the diploma engineers, my lord, who initially appointed as JE, junior engineer, my lord, and through distance education or something, Lord, they acquired engineering degree, my lord, graduation degree, my lord, bachelor degree, my lord, through AMI or something like that, through distance education, my lord. And therefore, my lord, they were appointed as assistant engineer. They are known as ABT engineers, appointment by transfer, my lord. So,
Appointment by?
yes, my lord.
No, appointment by transfer.
Appointment by transfer.
Appointment
Lord,
by
on
transfer,
acquiring-
my lord. I will deal with all those.
No,
provisions.
they have come from the other department.
No,
No, my lord, same department. They were working as junior engineer, my lord. They were
They got
initially.
promotion, they got.
No promotion, my lord. Diploma holder, my lord. What happened, my lord, during service as JE, my lord, they, my lord, through distance education or something, my lord, they acquired the bachelor degree, my lord.
The engineering qualification.
Please, my lord. And without facing any competition, my lord, they were appointed as assistant engineer, my lord. Like graduate assistant engineer, they were also appointed as assistant engineer, my lord.
Direct recruit.
No, neither direct.
It was a
recruit nor
provision under the
promotive,
rules.
lord. That I will deal with.
We'll
my lord.
see that. There is a provision under the rule.
Provision on.
If you acquire that qualification, you can.
That
come-
is, that is by the board order, my lord. Not the statutory regulation, that is by the board order, my lord. So what happened, my lord, and they are these appellants, my lord, the graduate assistant engineers, my lord, they are very senior to the ABT engineers, my lord, like 450 and 500 ranking senior, my lord. So what happened, my lord, the KPTC initially, my lord, the sent requisition for consideration of promotion to the direct recruit graduate assistant engineers, my lord. But thereafter, my lord, after 3 months, they sent the requisition for their consideration, my lord, ABT engineers. So we filed writ petition. They have also filed writ petition, my lord, and against the judgment of the learned single judge, my lord, the KPTCL has also filed writ appeal, my lord. So the judgment of the learned single judge is against me, my lord. And on the date of the consideration of promotion, my lord, this all the board orders, my lord, were withdrawn by the KPTCL, my lord. On the date of consideration of promotion to the post of assistant executive engineer, my lord, all provisions dealing with the ABT, my lord, were withdrawn by the KPTCL, my lord.
All the orders of the promotion.
Yes, all orders.
Promotion.
No, all orders, my lord, dealing with the provision of ABT were withdrawn, my lord.
Provision of ABT.
ABT, my lord.
The amendment.
Transfer.
Yes, my lord. In
But-
2000
yeah.
and 2015, my lord.
By an
And they
amendment.
have not challenged that, my lord. I will deal all those aspects, my lord.
By an amendment, the provision was, my lord, withdrawn in 2015. But we were all, my lord, under ABT, my lord, we were all included as assistant engineer, my lord, in 2011 itself.
But those orders have been withdrawn.
No. Only the provision relating to ABT has been, my lord, withdrawn, and the amendment has been brought in to stop the procedure for ABT.
That, my lord, 2015, my lord, provision, my lord, withdrawal of the scheme of ABT, my lord, that is prospective, not respective, my lord. So once they became AE, they will become AE, my lord. They will not be made JE with retrospective date, nothing like that, not, I will deal with all those issues. my lord. And the recent judgment of the Honorable Supreme Court, my lord, a three-judge bench judgment, my lord, in Rajkumar, my lord, Justice Narasimha, my lord, clearly the three-judge bench has said that the right to be considered for promotion as per the existing rules, my lord.
Okay.
So 230, my lord.
We have it up to lunch. Who appears for all the respondents?
And I represent private respondents, my lord. Some of them are represented by one.
We'll come back after lunch. Which is the connected?
Three connected appeals.
230, my lord.
Serial number 24, can it be kindly taken on 16th, my lords?
Which matter, ma'am?
Serial number 24, I'm given to understand it is passed over. Part of the papers are not.
Who appears for the?
DL and Rao is there, my lords. Another senior counsel, I have requested him and I have
Yeah, there is a passover sort in that.
passed over, my lords.
Yes.
24th, my lords. 24 matter, could it be kindly taken on 16th, my lords?
No, but who appears for the respondents? Who appear? Mr.
Appearing for the respondent.
You appear, Mr. Rao had appeared, no?
Yes, please.
DNL Rao, senior counsel DNL Rao is appearing. We have passed over the matter.
No, she is seeking an adjournment.
But
I have told and he said that 16th, if it could be taken, it's okay.
He has agreed for that?
Please, my lords. Yes.
Re-notify on 16th on the
Grateful,
request of
ma'am.
counsel for the
Appellant.
appellant. Senior counsel for the appellant.
So serial number 18, my lord, I'm seeking for an adjournment. I filed a memo for withdrawal, my lord.
Yes.
Yeah.
Your presence was required.
Yes, my lord, I'm so sorry. I'm not keeping good health, but still I came because your lordship.
There is a serious thing that has been informed to us.
My lord, no, those are all false allegations, my lord. I'll draw your lordship's attention, my lord, to your lordship's order, my lord, dated 17/10/2017, my lord. Impugned order was passed, my lord. But 15/10/2017, 2 days earlier to the order passed by this honorable court, action was taken by the first appellate tribunal, my lord. So this appeal became infructuous as on 2019 itself, my lord.
Where is the counsel? Yes.
My lord, when submission was made that it has become infructuous, it was repeatedly pointed out before several benches that it is not infructuous because allegations are made against all the respondents.
Withdrawal.
But more than all that, my lord, the fact remains that, as I pointed out, even reopening that case, the signature is not of the appellant.
My lord,
her thumb impression is repeatedly being misused. If she is asked to be present before the court, or if she cannot be present before the court, if a court commissioner to be appointed now, my lord, let him say where she is. We'll go there and ask her.
My lord, just
It
proof
can
of
be
patience, my lord.
videographed and
Appellant
produced
is
to
none
the
other than his own mother, my lord. He doesn't know where the mother is kept today. He's not
Yes.
taking care. He's trying to bring all the matters into this appeal, my lord, which is not relevant, my lord. Appeal has become infructuous as on 2019 itself, my lord. So this appeal does not survive for consideration. If he has any other grievance, let him approach the relevant MMTC court, my lord. Let him address his grievance there, my lord. Appeal has become infructuous. 1710 is the stay order, my lord. 1510, the order was acted upon by the first appellate tribunal. The fresh order I've challenged before the single bench, my lord. So this appeal does not survive, my lord. It has become infructuous.
My lord, my lord, may I?
See, wait. Let us assume that the withdrawal, LTM.
That is
etc.,
okay.
etc., that is different.
My lord, the question is, can
Now, he said that this has become infructuous in view of the
My-
subsequent order which
my
has
lord.
been passed and which has been again matter of challenge in the.
My lord, those submissions were already made by me and are noted. But the whole issue is not that. Is counsel acting with authority or not?
You were not aggrieved by the order passed by. Now
My
the
lord.
appeal is being dismissed.
My lord,
That order, whatever the benefit of the order is there, you will be entitled for that.
my lord, the issue is not
No,
that at
that's
all.
fine.
The point is that very clearly, the DC has also held that she is being set up by her youngest son to do all these things.
Correct.
Now, under these
Correct.
circumstances,
The appellant is this.
true, my lord,
Correct. But then what relief you can get?
My lord, the only relief is there an abuse of the process of this court or not? Is it with authority or without?
But this is inter-se between the mothers and the two sons, the litigation.
Yes, my lord.
Now tell us one thing, in any other litigation also the same plea has been advanced by you?
My lord, there's more than one litigation pending. We took up that contention before in
What
the writ
happened there? What
petition,
happened there?
in the DC gave a clear finding that she's set up by her youngest son and so
Setup
on.
is different.
Yes.
Setup is
And
different.
there
but
was,
As a setup person, she is signing it and she is putting
My
a
lord-
thumb impression is different.
my lord,
Let's
the
be-
question is she signing it or not? That is why I pointed out, even the signature there is not her signature.
My lord, he's trying to confuse this bench, my lord. Matters become infructuous. Unnecessarily is bringing on.
My lord, there is no confusion at all in this. The matter is simple. Counsel says that he has filed a wakalat with her thumb impression. Was she in a position to affix her thumb impression is one of the questions. Question is, where is she now? What has happened?
What is the basis for you to say?
My lord, my basis is only this, that counsel says on one hand that she is bedridden and she is not in her senses. He has said that in writing. Having said so, on what basis does he now say I am withdrawing the appeal? He should have her authority. He can't act without her authority.
You said so in any of your pleadings here?
My lord, no, I have orally submitted and it has been recorded by
I think
this.
this is something very serious.
It is serious, my lord.
And we must, if you want to file an affidavit, must file an affidavit so that we can take it to logical end.
Very well, my lord. It may kindly be adjourned. I will do.
Remark we will not allow.
No, it's not an off-the-cuff remark. I am making this with full
My
consciousness
lord,
of
I'm
what I'm
withdrawing
saying.
not based on her instruction, but the appeal has been infructuous, my lord.
Mr. Counsel, there is another issue also. He has raised an issue, possibly we will need to look into. If he wants to file an affidavit, but surely you'll be bound by the terms, by
Certainly,
the
ma'am.
contents of your affidavit.
Certainly.
We'll just adjourn it. Okay?
Yes.
Let's see that.
I place the memo on record.
We just file it.
May I point out, even the memo itself does not bear either her signature or her thumb impression.
The counsel.
Wherever you want to file it, you file it.
I'll do that.
The counsel for the appellant has filed a memo for withdrawal.
To be dismissed as infructuous.
Filed a memo contending that the present appeal be dismissed as infructuous. As the appeal has become infructuous, the same be dismissed as withdrawn.
Withdrawn.
No, this is the counsel who has filed it.
My lord.
Very well. And a counsel for the which respondent?
8 and 9, my lord.
8 and 9 seeks an adjournment. At his request, re-notify, come after 4 weeks. File it whatever you want.
My lord.
Grateful.
appointed by transfer. Deputy engineers are those who are basically appointed as a JE and appointed by the bachelor degree from distance education or JE, subsequently appointed as A without passing any test, without any competition. So clearly, there are two different and separate classes in this. One is direct engineers and one is AVP. And the AVP program will be at last law. Now, so these are very relevant for 3-4 cases. Undisputed cases. They have also not disputed. 2008 law, private respondents were appointed as JE, junior engineer, in 2008. 2008, private respondents were appointed as JE law, and on next date is 29/6/2010. Appellants law were appointed directly as assistant engineers on 29/6/2010. Then the third date is law between 7 to 11 to 1/7/2011 law. The private respondents became A assistant engineer between 7 to 11 to 1/7/2011. So there is no dispute that.
What is this date?
7 to 11 to 1/7/2011. 7 to 11 to 1/7/2011. 7 February 2011 to 1st July 2011.
What is the relevance?
Our appointment is private as assistant engineer. Because they are appointed on 29/6/2006 and they were appointed in 2011. So our appointment is private as assistant engineer, my lord. And my lord, on 3 different occasions, my lord, the seniority list was issued by the KPTCL, my lord. And we were shown more than 450 or 500 rank senior to the ABT engineers, my lord, and they never disputed, never challenged, my lord. On the 3 occasions were 1/4/2011, then 1/4/2014, and third one is 22nd July 2019. On all the 3 occasions, we were shown senior, not 1, 2, 3 rank, my lord, more than 450, 500 rank senior, my lord. And they never disputed, my lord, ABT engineers. So now, my lord, straight away I will come to your lordship's page 258, my lord. That is, next date is 3/6/2015, my lord. To page number 258, appeal paper book, my lord. Why I am showing so, my lord? Because the KPTCL, my lord, on 3/6/2005 took a conscious decision, 3/6/2015 took a conscious decision for withdrawal of the scheme of the ABT. 3/6/2015, Lord, 3rd June 2015, Lord, 3/6/2015, my lord, at page 258 of the appeal paper book, my lord. For a minute, my lord. 258, my lord. Page 258. I will read only relevant paragraph. My lord got it, my lord? Page 258. My lord, the subject is withdrawal of a scheme of appointment by transfer of in-service employees and withdrawal of a scheme of transfer of technically qualified employees working in ministerial cadres to technical cadre. Lord, third para, state away. The management has observed of late that many of the newly recruited ministerial and technical cadre employees are pursuing higher qualifications such as diploma and bachelor degree in engineering from deemed open university through correspondence and distance education modes. Earlier, the employees pursuing and acquiring higher qualifications in the field of engineering were very few. Since the year 2003, many vacant posts in the cadre of assistant engineer electrical civil and junior engineer electrical civil have been filled up by direct recruitment. Further, under the said scheme, some of the non-meritorious candidates are also being appointed with less number of years of experience, shouldering the higher responsibility, thereby compromising on the quality of engineers in the higher cadres. Consequent to this, the objective of recruiting meritorious candidates under direct recruitment quota
to technical cadre post is defeated. Moreover, the said scheme of appointment by transfer is creating a vacuum in the cutting edge level post, thereby large scale of vacancies under direct recruitment quota remains unfilled as recruitment to the said cadres are not taken up frequently. The utilities and undertaking large scale recruitment of meritorious candidates in the cutting edge level cadres. There is every possibility of large number of candidates with higher qualification than the prescribed minimum qualifications getting appointed in the lower cadres and thereby at the later date claiming appointment to technical cadres of junior engineer, electrical civil and assistant engineer, electrical civil by virtue of having acquiring technical qualifications of the said provisions are continued. Considering all the above, the board directors of KPTCL in the meeting held on 18th March 2015 debated the said issue and had resolved to withdraw with immediate effect all orders issued to the time with regard to appointment by transfer. So their eligibility is also gone, my lord. So order number so and so, my lord, as resolved in the 92nd meeting of the Board of Directors of KPTCL held on 18th March 2015, approval is hereby accorded for withdrawal with immediate effect of the following. First, all orders issued from time to time relating to appointment by transfer of employees. Then third, my lord, or second, my lord, order number so and so issued earlier with regard to transfer of technically qualified senior assistant, junior engineers. Third, important, my lord, all amendments made into the KEB and RMP regulations with regard to the appointment by transfer of in-service junior engineers against direct recruitment quota to the cadre of assistant engineer graduate, my lord. Fourth, all amendments made into the KEB RMP regulations with regard to the appointment by transfer of in-service employees against direct recruitment quota to the cadre of junior engineer civil, my lord. Then last paragraph is very important, my lord. Further approval is hereby recorded for processing only such of the pending instances of the claims of the employees as on 18th March 2015, seeking appointment by transfer from the cadre of junior engineer to the cadre of assistant engineer in accordance with the rules and regulations which were prevailing earlier to the withdrawal of the said scheme, my lord. Lord, this order was passed, my lord, in view of the administrative offences, my lord, in the engineering services, my lord, and no challenge by them to the legality and validity of this order, my lord. No challenge that I will show, my lord, subsequently, my lord. There is no such prayer in their writ petitions, my lord, which was issued, my lord, on 3rd June 2015, my lord. Then, my lord, kindly come to page 83 for the reason that what is the length of service required for promotion to the post of assistant executive engineer, page 83. I'm coming. First, I will show 83. 83, my lord. 83, my lord, because these regulations, 83. 27 July 2016. Yes. Page 83, my lord. Page 83, my lord, these regulations shall be called the Karnataka Electricity Board Recruitment and Promotion Regulations, Employees Probation Regulations, and Employees Seniority Amendment Regulations 2016 as hereunder. These shall come into force with effect from 6/6/2016, my lord. So straight away, page 86, my lord. Page 86, my lord, column 8. Because we are concerned with the post of assistant executive engineers. Column 8 is, my lord. First heading is as existing, then as amended, my lord. My lord, got it, my lord? column 8, my lord, assistant executive engineer, my lord, should have completed 5 years of service as assistant engineer. Note, provided that if officers who have put in a minimum service of 5 years are not available, on officer who has put in 3 years of service may be considered by promotion as amended. Should have completed 8 years of service as assistant engineer. Note, provided that if officers who have put in a minimum service of 8 years are not available, on an officer who has put in 6 years service may be considered for promotion. So we fulfill this criteria. Then page 264, my lord. There was further amendment, my lord, 264.
Page?
264, my lord. Page 264, my lord. It starts from 261 and the relevant portion I want to show at page 264, my lord. The same, my lord, Karnataka Electricity Board Recruitment and Promotion Regulations, my lord. Issued on 28th March 2018, my lord. It starts at page 261. 28th March 2019. And my lord, relevant is page 264. Again, my lord, column 6, assistant executive engineer, graduate, as existing, should have completed 8 years of service as assistant engineer. Note, provided that if officers who have put in minimum service of 8 years are not available, an officer who has put in 6 years of service may be considered for promotion as amended. Next column, my lord, should have completed 6 years of service as assistant engineer. Note, provided that if officers who have put in a minimum service of 6 years are not available, an officer who has put in 5 years of service may be considered for promotions.
This is when, what is the date of this?
My lord, 28 March 2019, my lord. That it starts from page 261, my lord. 28th March 2019, my lord, page 261.
Yes.
Then, my lord, what happened at page 137, my lord? Page 137, everything was going right, my lord. Page 137, we were called for document verification, my lord, for consideration of promotion to the post of assistant executive engineer, my lord. At page 137, my lord. This is in Kannada language, but translated copy is also there, my lord, at page 141.
What is your present designation?
We are assistant
Still assistant engineer.
Yes, because of this litigation, my lord. So page 137, my lord, we received one communication for consideration of promotion to the post of assistant executive engineer for documents verification, my lord. Name of all the petitioners are here, my lord. 75, 79, 80, 86. All petitioners are there, my lord.
So how many are there? 3 to 5?
Yes, my lord. Then what happened, my lord? At page, my lord, 142, my lord. Problem starts from here. Page 142, my lord. This is again, my lord, in Kannada language, my lord. After 3 months, my lord. First communication was issued in the month of March, my lord, 2018. Then, my lord, this is 12th June 2018. My lord. After 3 months, my lord, ABT engineers were called for document verification, my lord. After 3 months. English translation is at page 148, my lord. The problem starts from here, my lord.
What do you call them? ADB?
ABT, my lord. Appointment by transfer, my lord.
ABT?
Engineers, my lord. That I will deal it separately, my lord, according to me, my lord. All ABT engineers, backdoor appointment, my lord. That I will show, my lord. Without facing any competition, my lord. And I will show provision, my lord, without even following roster reservation also, my lord.
Yes.
That Lord Acton famous saying, my lord, the absolute power corrupts absolutely. Same will apply here, my lord. That I will demonstrate.
Yes.
Next page, my lord, 159, my lord. 159. Here, my lord. This again, communication, my lord, to the ABT engineers, my lord. That will become very clear, my lord. Request to provide information of assistant engineers to verify the eligibility of promotion, my lord.
This is for you.
No, no, my lord. This is for the ABT engineers, my lord.
How do we get that?
My lord, their names are there, my lord.
So only by names.
80, 81, my lord. 79, 80, 81, my lord. So these two communications, my lord, 21st June 2018 and 22nd June 2018, my lord, being agreed, my lord, we challenge before this honorable court by way of writ petition, my lord.
But they thereafter brought a seniority list where you were shown above you.
Whom,
But you were shown higher than them. In 2019.
No, no, my lord. 2000, since beginning on 3 occasions when
That's right. Last occasion is 22/12/19.
Yes.
You said 22/12/19.
22, 719, we were shown senior.
22.
719.
So you were shown above.
Yes, yes, on all the 3 occasions, my lord.
Okay.
I already pointed out, it is my mistake, my lord. On 1/4/2011.
That we have noted.
Okay. On all.
Now what happened after this?
This communication, we challenge challenge this communication before this honorable court, before the learned single judge, my lord. But before coming to the impugned judgment, my lord, I want to show 3-4 provisions of the statutory regulations, my lord. That is at page 169.
Regulations regarding?
Regarding the seniority, promotion, because that is very statutory regulations, my lord. Because I will deal with the judgment of the learned single judge, my lord, I will try to show your lordships that the learned single judge bypassed the statutory provisions. Therefore, I have come to this point.
Let's see which page.
169, my lord. My lord got it, no? Oh, sorry.
English.
169.
English version.
English version, my lord. English version. Kannada and English, both, my lord. I will read only English part. Page 169.
Yes.
Karnataka Electricity Board Recruitment and Promotion Regulations. In exercise of the powers conferred under Section 79C of the Electricity Supply Act 1948, the Karnataka Electricity Board hereby make the following regulations, namely, these regulations may be called the Karnataka Electricity Board Recruitment and Promotion Regulations. Now straight away come to page 181, my lord. Very important.
These are promotion regulations.
Please, my lord. Page 181, my lord. My lord, the 7th bottom, page 181, procedure of promotion, my lord. The promotions of eligible employees shall be made on seniority cum merit basis, my lord. Seniority cum merit basis, exceptions are only for the post of chief engineer, my lord.
Where are you reading?
My lord, page 181, 7, column 7, my lord, procedure of promotion, my lord. Page 181, my lord. Here, my lord. Bottom, my lord. Page 181, bottom.
That's 182.
181, my lord. Page 181.
Our page is 182.
Sorry, sorry.
That's procedure for promotion, na?
Please, my lord. Please, my lord.
Yes.
Lord, the promotions of eligible employees shall be made on seniority cum merit basis, my lord.
Right.
Exceptions are only chief engineer. Last 3 lines, my lord. However, the criteria of promotion on the basis of seniority cum merit shall also be based on the confidential reports of the employees concerned for a period of at least preceding 5 years in case of regular establishment, and performance report of a period of at least preceding 3 years in the case of maintenance establishment. Then page 201, my lord.
No, where were you reading? Acha, okay. You show us the seniority rule. Now what happened now in this? After they called for those names for document verification, then what happened?
Then
you challenged it. What is the grievance of yours?
My grievance is the criteria of promotion is seniority cum merit. Then the KPTCL should have given promotion first to us.
So your grievance is against non-promotion.
Please, my lord.
Now, was there any seniority list issued before
lord.
they make promotion?
No, they did not make any promotion to them and us also.
Not understanding.
Please,
What does the rule say, promotion rule? Seniority come merit.
please, my lord.
Seniority, you remain to be senior to them.
Please, my lord.
No dispute.
Yes, my lord.
Even on the date of promotion, you were senior.
Please, no.
You were senior,
No promotion, my lord. Direct recruiter, assistant engineers, my lord.
but they have been given promotion.
No, my lord.
They have not been given.
No.
Then what is the grievance?
Grievance is that, my lord, see, instead of giving promotions to us, they ask for the ABT engineers to consider their case of promotion to the post of assistant.
Have they been promoted?
No, my lord.
Then where is the grievance?
Please, my lord.
Where is the grievance?
Grievance?
They have only asked for the name. Did they actually promote them?
No, they did not promote them, my lord. So
So
they
very-
also filed writ petition. We also filed writ petition.
They asked for giving promotion to them. Did they ask for promotion to them?
They, my lord, in spite of being a junior, they filed the writ petition before this honorable court,
Seeking,
seeking a promotion to the post of assistant executive engineer.
have they been accepted? Their prayer has been accepted?
No, my lord, the learned single judge passed the judgment saying that,
Yes.
I will come to, learned single judge passed the judgment saying that you give weightage to them and promote them.
So that's the direction.
Please, my lord, I will
Let's
come
see-
to that issue.
Let's see the direction.
Lord,
Straight-
first, only 2 pages I will show, my lord, from regulations.
Let's see the directions on the whether.
Page 66. Page 66, my lord.
So their 1/3 of service as junior engineer to be counted.
Subject to 4 years for the purpose of eligibility, my lord. But the statutory regulations provide the criteria of promotion is seniority cum merit, my lord. I will come, my lord. Give me 2-3 minutes time.
Yeah, the base of data.
My submission is that the learned single judge bypassed the statutory provisions, my lord. Page 181, my lord, I have read.
Yes, come to 180.
Yes, my lord. Page 201, my lord. 201. My lord got it. These regulations may be called Karnataka Electricity Board Employee Seniority Regulations. Seniority means the relative place of an employee in the order of ranking in a particular cadre. Then next page, my lord. Rule 2. Subject to the provisions hereinafter contained, the seniority of an employee in a particular cadre of service shall be determined as follows. A. Employees appointed substantively in clear vacancies shall be senior to all persons appointed on officiating or any other basis in the same cadre of service. B. The seniority inter se of employees who are confirmed shall be determined according to dates of confirmation, but where the date of confirmation of any two employees is the same, their relative seniority will be determined by their seniority inter se while officiating in the same post, and if not by their seniority inter se in the lower cadre. Then next 3, my lord. Where employees are recruited to any service by promotion and by direct recruitment, the employees directly recruited will take precedence over the promoted employees in case.
Where are you reading? 3.
3, my lord. 3, I'm reading. Where employees are recruited to any service by promotion or by direct recruitment, the employees directly recruited will take precedence over the promoted employees in case where the date of appointment is the same.
Okay.
Then next, my lord, last 4. Where promotions to a cadre is made on the basis of seniority cum merit, at the same time, the relative seniority shall be determined 1 if promotions are made from any one cadre by their seniority inter se in the lower cadre, my lord. So these are the relevant statutory regulations, my lord, which provides that the seniority, the criteria of promotion as assistant executive engineer is seniority cum merit, my lord. So now, my lord, now I will come to the provisions dealing with the ABT engineers, my lord. That what is the ABT? Page 229, my lord. Then I will come to the impugned judgment, my lord. Page 229.
Now, which provisions shall help you in 2 and 3 of seniority?
Please, my lord.
This page 202.
202.
which, according to you, which regulation will govern the seniority? According to you, the inter se seniority between you and the ABT is governed by which rule?
That is two, sir, two. So, 2A, subject to the provisions hereinafter contained the senior.
Employees appointed substantially in clear vacancy shall be senior to all persons appointed officiating or any other basis. Very well. There is no issue on that.
No, my lord.
You were substantially appointed.
Please, my lord.
They were also substantively appointed.
No,
Why?
they were appointed as JE. During in service, they obtained the bachelor degree from distance education and something. And thereafter, they were appointed as.
But your appointment as AE was prior to them.
Please, my lord. And this statutory regulation, my lord, provides that the criteria of promotion to the post of AEE is seniority cum merit, my lord. And we are senior. They have not disputed my seniority.
Your seniority has not been disturbed.
No, my lord.
Very well. So seniority has not been disturbed.
No, my lord.
Where does the rule say, the direction given by the learned single judge is that their case will be considered for promotion counting 1/3 of the service as a JE?
Please, my lord.
How do you get that? How does the learned single judge get that?
I will come to before, my lord, come to that learned single judge judgment. I will deal with ABT in 5 minutes, then I will come to that. ABT, my lord. Page 229, my lord.
Page
229.
Yes, what is this 229?
The 26th July 1986, my lord, for the first time this ABT provision came into existence, my lord.
Okay.
Bottom, my lord, in the circumstances, approval is accorded to amend the
Recruitment rules.
KEB recruitment and promotion of the employees of the Board Service Regulations 1969 in respect of assistant engineer electrical and civil as follows. By direct recruitment or by transfer of a qualified in-service junior engineer who possesses or acquires BE or AMI qualifications and by departmental promotion as detailed below. Then next, my lord. Note 4, my lord. Note 4. The transfer shall be effective from the date of graduation, subject to the availability of vacancies without ignoring the inter se seniority among those eligible for such transfer. Then note 5, my lord. The junior engineer who is appointed by transfer as assistant engineer on or after 1/1/76 shall be entitled to count 1/3 of the service rendered by him as junior engineer prior to appointment as assistant engineer, subject to a maximum period of 4 years, as if it had been in the post of assistant engineer for the purpose of consideration of promotion for the post of the assistant executive engineer and subject to the following conditions, namely: 1. The seniority of a junior engineer who is appointed as assistant engineer shall be fixed in the category of assistant engineers with reference to the notional date arrived at after giving weightage of service as aforesaid. Second, a junior engineer who is appointed as assistant engineer shall be put in a minimum service of 2 years on duty as assistant engineer after such appointment and total service of 5 years as assistant engineer inclusive of the service given as weightage to become eligible for promotion as assistant executive engineer, my lord. Then next page is, my lord, very important. 2, bottom.
Just 1 minute. Yes.
Next is very important, my lord. Page 231, bottom column 2, my lord. Date of effect. The above amendment shall be deemed to have come into force on the 1st day of January 1976, my lord, 10 years back, my lord. Because this provision was incorporated in July 86 with effect from January 1976, my lord. Then 4 is also important at page 232, my lord. 4. reservation under roster system is not applicable in the case of transfer of junior engineers to the post of assistant engineers against direct recruitment vacancy, my lord. So the constitutional mandate has also been violated, my lord, here, my lord.
Now tell us one thing, when were these issued, these instructions?
Please, my lord.
When was this order issued? 1986?
Please, my lord. With effect from 76, my lord.
That's right, but you were not in service.
No,
this
I'm
day.
not, I'm just, what is the history of the ABT engineers, my lord, I am saying. Then, my lord, what happened? The next page is 242, my lord.
And
242.
this continued till that resolution was passed.
Please, my lord. No, before that, the ABT, my lord, this KPTCL withdrew that policy, my lord.
When was that?
In 2015, my lord.
2015.
Please, my lord, that I have shown, my lord.
See, ABT, the respondents have withdrawn the order of bringing in assistant engineer through transfer. That they have withdrawn.
Please, my lord.
Bringing junior engineers on transfer as AE has been withdrawn.
Please, my lord.
So that process of making promotion or transfer to AE post has been withdrawn.
Please, my lord.
Now, very well. The question is whether they can implement these recruitment, these promotion rules or seniority rules.
Please, my lord.
In respect of those people who have already come on transfer as AEs.
Please,
for promotion.
Please, my lord.
Getting the point?
Please, my lord.
That's the point.
Please, I'm coming to that issue. Then what happened, my lord? This provision, this ABT provision was challenged before this honorable court, my lord.
Okay.
And the division bench, my lord, that Bruce Ripper judgment, my lord. Bruce Ripper judgment, my lord, at page, I have seen, my lord, that that rosters, reservation roster is not applicable, my lord. Then 242, my lord. Bruce Ripper judgment, my lord. Division bench of this honorable court, my lord. The date of Bruce Ripper judgment is 23rd January 1996, my lord. I will read, my lord, page 2545, bottom, my lord. In this case, for the very reasons stated by the Supreme Court in Narayanan case, we hold that the rules or notes or regulations being given retrospective effect from 1/176 is struck down as ultra vires. The note relating to giving weightage shall be read as providing eligibility only. And third, the respondents are directed to prepare fresh gradation list in the light of this order and in the light of the observations made by the Supreme Court in Narayanan case referred to earlier. In Supreme Court, my lord, following the divisional bench followed K. Narayanan judgment of the Supreme Court, my lord, and the judgment passed by the K. Narayanan, my lord, in another judgment of the Supreme Court, Sudhakar Rao, my lord, confirmed the same view. Then 247, my lord. 247, then in view of this Bruce Ripper judgment, my lord, the KPTCL, my lord, replace the provisions, certain provisions dealing with the ABT, my lord. 242, my lord. 247, sorry. 247. Here, my lord, second paragraph, this Bruce Ripper judgment has been dealt, my lord. The Honorable High Court orders dated 23rd January 96 disposing of writ petition, so and so, in terms of the order of the Honorable
So
Supreme.
instead of now 1976, what will be counted is after 86.
Please, my lord.
Whosoever they will come on transfer as AE.
Please, my lord.
Their 1/3 of service subject to maximum 4 years would be counted.
As weightage, not for the purpose of seniority.
Not for the purpose of, for the weightage, for the purpose of promotion.
Promotions. And my lord, then my lord, page 252, my lord. Page 252, bottom, my lord. This approval is accorded to replace the existing paras note 4 under para 2 and 2 under so and so, dated so and so, as under a junior engineer electrical who acquires, possesses or AMI India qualifications in electrical, mechanical, electronics, telecommunications, so and so, appointed by way of transfer from the post of operator, overseer, meter reader, assistant, storekeeper, or acquiring, possessing BE or AMI India qualifications shall be put in minimum period of 7 years of service as junior engineer to become eligible for appointment by transfer to the post of assistant engineer electrical. The appointment shall be subject to the availability of vacancies without ignoring the interstate seniority among those eligible for transfers. So these are the provisions, my lord, dealing with the ABT engineers. my
No,
lord.
which one you were reading? Yeah,
Lord.
252.
Please, my lord, 252 bottom, my lord.
Hmm.
That 27th,
To
December
acquire further
1996,
BE
my lord.
engine
May I read, my lord?
by
One
way
second.
of transfer from the date of overseas agent. There is no junior engineer here.
No, here, my lord. A junior engineer, note 5, my lord. A junior engineer electrical, my lord got it, my lord. Note 4, para 2, my lord. Last 3-4 lines, my lord. Bottom, my lord.
I junior engineer.
Please. my lord. So these are the provisions, my lord, dealing with the ABT
Does
engineer.
it say who acquire further BE
7 years, my lord.
minimum of 7 years of service to become eligible for appointment by way of transfer to the post of assistant engineer civil? The appointment shall be subject to the availability. So after 1986. No, after 1986, no?
Please, my lord.
Yes.
Please, my lord.
After, no, what is the effect of this order? From which date?
1996, my lord.
Right.
That order says 96, but it has to be given retrospective effect from the date of the
Initial, the
Initial.
initial, that
Please,
86.
Lord.
that
Word
is-
has been used, replaced. So it has to be given with retrospective effect
from-
86.
From 26/7/86.
Please, my lord.
So 26/7/86, it would be 7 years.
Please, my lord.
Okay.
Now, my lord, straight away I will come to the impugned judgment passed by the learned Singh judge. Then I will,
No, but you must tell us what is now, on what ground you are, what is the proposition you are advancing?
my proposition is that, first, the statutory regulation provides that the criteria of promotion to the post of assistant executive engineer is seniority cum merit. And we are consistently senior to the ABT engineers because our date of appointment is prior in time. So we should be considered first for promotion to the post of assistant executive engineer.
Now, what is the date on which they are seeing the eligibility? What is the date of, what is the date on which they are determining the eligibility for promotion? What is the date, cutoff date?
My lord, cutoff date, my lord, because see,
Very well. We can, the date when they sent, when they asked for your
2018, my lord.
2018.
Yeah, 2018.
May I give the date?
21st June 2018 and 22nd June 2018. There.
You appear for whom?
For the ABT engineer.
And my,
So who appears for the department?
not here.
Acha, you appear for them?
No, my lord, the
We were,
May-
just 1 second, 1 second.
No, just we want to know. What is the date for determining the eligibility, that whether they have the eligibility for promotion?
Lord, we became eligible on 7/11/2017.
You?
Became eligible for promotion.
When did they become eligible?
On 29/6/2018.
Why do you say so they became in 18?
Because 8 years of service rendered, only the experience of 8 years is mandatory for promotion.
But that has undergone a change, na?
No. As on the
Just
date when this circular was issued, it was 8 years. 2019 is the amendment.
2019?
19 is the amendment. But my lord, 2018, the lordship would get
Kindly see, my lord, come to, no, my learned friend is
So
not
let's
correct,
check-
my lord.
Let's check that.
the lordship may kindly see the 8 years category, my lord, the circular was issued on 21/6/2018.
Let's see that 137,
My lord, kindly come to page 86.
137.
not 137, sorry.
The amendment, first amendment in
The-
2018, my lord, that is 8 years, my lord.
No, my lord, bottom note, my learned friend is not reading the note, my lord.
1 minute, please. Just hold on. 182. Not 182.
86, my lord, 86, my lord.
1?
Only 86, my lord, 86.
You have given us so many documents.
It starts from page 83, but relevant is 86.
No. 1202.
But the first amendment that was read out by my learned friend is at page.
Yes.
Lord, provided that if officers.
Yes. Where is that recruitment rule, promotion rule, which says 6 years?
Right, that
is
page,
at,
page 86, my
264,
lord, 86, my lord.
Page
264
is the amendment.
Page 86, my lord, it starts from page 83, but relevant is 86. Column 8, my lord.
86 has said 8 years, 264 has reduced it to 6 years.
Now 86 is which date? 2016.
Yes.
Okay, now come to 264. 264 says 6 years.
28 to 2019.
Oh, that's 19.
Yes.
What is the date?
28.
319.
319. Okay.
Yes, sir.
Now.
Even, yes, ma'am. Even as, my lord, 27 July 2016, we were eligible, my lord.
You were eligible with 8 years.
My lord, I will be, see the, first is should have completed 8 years of service.
You are Mr. Parimal.
Please, my lord.
Mr. Parimal, tell us one thing. You were appointed when? You were appointed as in 2010?
Please, my lord, 29th June 2010, my lord.
Very well. So in terms of page 83, requirement is 8 years.
Please, my lord. No, note, my lord. I am giving emphasis on note also, my lord. Note.
Okay, let's read the note.
Provided that
An
my lord-
officer who have put in minimum service of 8 years and are not available,
Yes, my lord.
who has put in 6 years or maybe altered.
Please, my lord.
Now, is it their case or is it your case
Please, my lord.
that persons with 8 years were not available at all?
Yes, my lord.
How do you say so?
Lord, KPTCL is here, my lord, and for 8 years, my lord, only few days short, my lord. Only few days short.
Your seniority is at 75.
Please, my lord.
Your seniority position is 75.
Please, my lord.
That as per that list.
Please, my lord.
Anyone above 75 are also available who had put in 8 years of service?
Lord, the KPTCL is here, my lord. They will.
But you must tell us.
I will make inquiry, my lord. I will respond.
No.
I will respond to that. I will respond to that. I will respond to
the circular. We were available with 8 years of service, and therefore the circular was issued calling our name for CS.
1 minute. Tell us one thing.
But my instruction is that half of them are from 2006 batch, my lord.
No, let's see that seniority list. We'll just know. Where is that seniority list where you said you are at 75?
Please. Annexure C, my lord.
Annexure?
C.
No, what is the page?
Yes, my lord. 139, my lord. This is not the seniority list. This is not the seniority list, my lord.
Very well, it's not the, no, very well, it's not the seniority.
Departmental inquiry, my lord, at promotion, my lord, page 139, serial number 55, my lord.
And how many vacancies were there?
How many?
How many were there vacancies?
About 100, my lord.
There were 100 vacancies.
Please, my lord.
Okay. And anyone above them, above you,
Please, my lord.
were also considered?
Yes, considered.
2007 batch.
They are which batch?
2010.
Or 2007 also considered? Now, against these, there are 100 vacancies.
Number at that date, I'm not aware. That date.
But tell us one thing, between 2007 and 2010, how many people were eligible based on 8 years? See that 6 years will trigger only when 8 years are not available. Okay. If 8 years are available between 2007 and 2009, let's assume 2007, 2009 batch.
After 2007, the next batch of 2010.
Oh, so the next is 2010. Now, how many were 2007 were available with 8 years? Or no one was available for 8 years?
80.
No, it cannot be because 2000 and this is 2018. So 2000 means 8 years and 3 years. 11 years people were also available. You're getting? when a batch is of 2007, you are considering 2018, yet call the names in 2018?
Yes, but of the batch of 2010 and 2011 and 2007, they applied that 8 years eligibility only at that.
2007 were not promoted till 2018? They were not? How many of 2007 were available with 8 years? When it was 2007 was considered in 2018, must be all were available. Of 2007, how many were available?
How many were there of 2007 batch?
That date, I'm not very sure, 2018.
See, this will have a bearing on the interpretation of the rule. Let's assume we will tell you how. 2007, there were 100 vacancies according to him. That you have to check up. Let's take it, there were 100 vacancies. 2000 batch consists of 50 people. Okay. All 50 were eligible having 8 years of experience because they had 11 years of experience rather. Why? But there were 50 who were not available. So 50 with 8 years, rest balance 50 with 8 years were not available. So that 6 years will come in. 6 years get triggered. Getting? If 6 years get triggered, according to them, we were eligible. Because that 6 years will come in now. Because 8 years, no one is available. But vacancies are there. So 50 vacancies were there, but 8 years people were not available. 6 years will come in. So they say 6 years we fulfill. Getting the point? That's one. Now what, according to them, is they were not eligible going by 8 years. And you must also consider this. So if they get eligibility in 2018 with 6 years, according to them, they attained eligibility before them. That means before 2018, they got eligibility. Hence, they have a prior right to be considered. That's their case which is being set up. But if they achieve 6 years in 2018, why 2018? They will achieve 6 years in 2016 only. Because their appointment is 2010. So 6 years they achieve 6 years of eligibility. So their date of eligibility would be 2016. But as against you, what is your date of eligibility?
If it is 6 years, I would become on 7/11/2015, I will become eligible.
No, 1 minute. That 6 years would not be eligible to you.
I'm entitled. Because counting the date of, counting the 1/3 service as eligibility, I would become eligible with 6 years on 7/11/2015.
Achha, prior to them.
Yes.
On that formula.
Yes, their appointment is only in 2011, Milord, subsequent to us, Milord.
Right, but
and the criteria of promotion is seen. Just
so you are not getting, Mr. Piramal. You must also examine. Your eligibility is dehoes the counting of junior engineer service.
Please, Milord.
But their service is how much of service?
1/3 means it will be 4 years.
1/3 means if ultimately 9 years means 3 years would be counted.
No. What happened to that statutory regulation which prescribes seniority come merit, Milord? It means that if the ABT engineers fall under the, just 1 second, Milord. If ABT engineers fall under the category of seniority, but their length of service is less, Milord, that 1/3 subject to 4 years shall be counted, Milord.
Right. See, eligibility is different and seniority cum merit is different. Seniority cum merit comes into play when merit being equal, it's the seniority which will determine who will go first, who will get promotion. But here what he is saying is on the basis of this principle, 1/3 need to be counted. They get eligibility before you.
Milord, but this regulation, Milord, the statutory regulation cannot be bypassed, Milord.
Which statutory regulation?
Please. Page 181, Milord. Page 181, Milord. Procedure of promotion, Milord. The promotions of eligible employees shall be made on seniority cum merit basis, Milord.
You are not understanding. There is no dispute. It has to be seniority cum merit.
Please, Milord.
But who would be considered first would be an issue.
Please, my lord. And now, my lord, next
We'll
is,
do one thing, just 1 minute. See, you will now tell us this. How many vacancies were there? How many people were eligible? Okay. When did they become eligible? When did they become eligible? On the basis of the statutory regulation. There is no dispute. 8 years and 6 years will come in their way, will govern them. So he says, when the rule says if the 8 years people are not available, then you will reduce the eligibility to 6 years. You will see their case, and you will see in their case also, when did they get eligibility in terms of this rule, where you say 1/3 would be counted for the purpose of determining the eligibility.
my lord, the eligibility.
will work out
My lord, with great respect, my lord, eligibility ipso facto, my lord, does not confer entitlement, my lord. Eligibility ipso facto does not confer entitlement.
We will put it to you, Mr. Parimal.
202, my lord.
We will tell you for you to look into it.
And my lord, page 2.
We will tell you, just wait. You may be senior,
Please,
no
my lord.
dispute.
Please, my lord.
They are junior,
Please, my lord.
no dispute.
Please, my lord.
Before you attain eligibility, they are getting eligibility. Getting the point? You are seniors. Seniority itself would not be a basis for promotion. You have to meet the eligibility also. Getting the point? I
Please,
hope we are clear.
My lord,
Just listen to us. You may attain eligibility. He will attain eligibility before you attain eligibility. But you are senior, but you will still not be considered because their eligibility has come in.
no, but if see, page 202, my lord. Page 202. I told you. I'm coming, Lord. 202, my Lord. 202. Subject to the, my Lord got it, my Lord. Page 20. Subject to the provisions hereinafter contained, the seniority of an employee in a particular cadre of service shall be determined as follows. A. Employees appointed substantively in clear vacancies shall be senior to all persons appointed on officiating or any other basis in the same cadre or service. B. The seniority inter se of employees who are confirmed shall be determined according to dates of confirmation, but where the date of confirmation of any two employees is the same, their relative seniority will be determined by this seniority inter se while officiating in the same post, and if not, by their seniority inter se in the lower cadre, my lord. My submission is that, my lord, that we were appointed as direct recruit assistant engineer, my lord, in 2010. They were appointed as assistant engineer in 2011, my lord. By Supreme Court judgment and by Guru Sripat judgment of this honorable court, my lord, the retrospective seniority of the ABT engineers were withdrawn, my lord. They were put in the bottom, my lord. And again, my lord, if the seniority merits principal side be sidelined, my lord. Again, they will be given promotion, my lord. Then what is the relevance of the judgment, my lord? Number one. Number two, just one, I'm concluding. It's extremely sorry. Number two, my lord, the criteria of seniority cum merit means, my lord, according to my understanding, my lord, if they fall under the, that fulfill the seniority criteria, my lord, but their length of service is less, my lord, then 1/3 service subject to maximum 4 years shall be added for consideration of promotion to the post of assistant executive engineer, my lord. First they have to satisfy that they fall under the seniority list, my lord. Otherwise, my lord, then retrospective seniority gone, my lord. Then against the, by way of eligibility, they will come, my lord. Then and last month, in Excel L, my lord, page 258, my lord, 258. 258. 258. Please, my lord. I have read, my lord, then read all board orders, my lord. Order number so and so dated 2686, order number so and so 27/12/96, third order number so and so 27 page 258, my lord. Withdrawal of a scheme, my lord. Read 1, 2, 3, 4 up to 7, my lord. Please, my lord. They have review, my lord. Everything will with the complete board orders, my lord. 27/12/96. No, that is not with retrospective effect, my lord. Please, my lord. Yes, my lord. So it will apply. Yes, my lord. So and the Supreme Court judgment says, my lord, that the right to be considered, promotion, my lord, as per the existing rules, my lord. Please, my lord. So and they have not challenged this withdrawal AVT scheme, my lord.
We want to know from you. Now, after they have withdrawn the scheme from 76, the High Court says 76 is bad, and rightly 76 is bad. Now, if we give an effect from 1986, okay, then what is the effect of 1986?
Lord, 1986, my lord, the 1/3 service earlier to in 1986, my lord, 1/3 service was counted both for seniority as well as for date of eligibility for promotion.
No.
In 86. Yes. Yes. Only for the purpose of determining the eligibility for promotion, my lord, 1/3 service has to be counted. Yes. Yes. Yes.
When were you appointed?
In 2008, my lord.
As
JE. Yes, my lord.
Now, when were you paid as an AD?
7/2/2011. 2011.
So you been daily service effectively 3 years.
Yes.
3 years, 1/3 of 3 years in
1 year.
Now, from 2011 to what is the date, the cutoff date for promotion to AD?
Cutoff date for promotion. Experience of 8 years, my lord. Lord, on 7/11/2017, I will become eligible. 7/11/2017 with 8 years, my lord, I will become eligible for 2017. No, that is because, my lord, counting the 1/3 eligibility service. Is only for the purpose of determining the eligible promotion.
Yes.
6 years. If it is 6 years, I'll become eligible in 15.
Let's say that. So it is 6 years plus 1 year service in AD.
Yeah.
So it will be 7 if you will become eligible in 2018.
No, my lord. My lord, if 6 years is counted, my lord. Okay.
Yes, yes.
Says it once he gave the status.
Yes, ma'am.
8 years means. 8 years.
I would become eligible on 7/11/2017. Because I will get the benefit of 2 years of 1/3 service. No, 2008. 3 years. My lord, I'll count, as per my calculation, my lord, the date of eligibility is 2008, may not be correct, my lord. As per the calculation, what I have done, my lord, 2000, they were appointed as JEs, my lord, much prior to 2008. The service, 1/3 service, if it is counted, my lord, they entered the AE cadre on 7/11/2011, my lord. They entered the JE cadre. Yes. Yes, yes, ma'am. Yes, ma'am.
8 years is the eligibility for.
Yes, ma'am.
So you will get benefit of
Yes, ma'am.
extra. So you will become 2017 eligible.
Yes, ma'am.
For 8 eligible.
Yes, ma'am.
Mr. Parinda, I hope you are following it up on the.
I will respond to that, my lord. Yes.
According to Mr. Parinda, that it is 8 years, they were appointed in 2010.
10. Yes, my lord. And that is my case. Please, my lord. The department maintains the seniority list, my lord, as from the date of promotion, my lord. Suppose A is promoted first, my lord, as assistant executive engineer. In seniority list, he will be at the top, my lord. Then B, my lord. So suppose, my lord, if they will promoted as assistant executive engineer first, my lord, despite they joined assistant engineer in 2011, my lord, and we joined at 2010, my lord. In the cadre of assistant executive engineer, my lord, again they will be senior, my lord, because they will say that I'm senior. Earlier the cadre, my lord. So that was not the intention, my lord, with the Guru Sripat judgment and the judgment passed by the K. Narayanan and this Sudhakar Rao judgment, my lord. Because one second, my lord, because once the Sudhakar Rao judgment and Guru Sripat judgment, K. Narayanan judgment says, my lord, that they shall not be given the retrospective seniority, my lord. So one hand, my lord, the judgment says retrospective seniority may not be given. But the other hand, my lord, by way of eligibility, again they will jump and they will become senior to us, my lord, although they are junior to us. So one hand. No, but the problem will arise, my lord. How the department will prepare the seniority list?
If you are wrongly, if a person goes to the order first, he will rank senior.
Please, my lord. 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 Please, my lord.
When it comes to promotion, seniority is not only the criteria. You will just listen. Eligibility is also a criteria. If I am senior, hypothetically, if I am senior, then my law.
Please, my lord.
But for promotion, if I don't have the eligibility, I will not be considered, even though I am senior. It is the point.
Please, my lord. I may answer to that, my lord. When the statutory regulation provides, my lord, the criteria of promotion is seniority cum merit. But seniority alone cannot be considered. The merit part of 4 years or 5 years of ACR shall also be taken into consideration. That I have shown to your lordships, my lord. Again, I can show, my lord. So the first and foremost criteria is that a person should be senior. Then second part would be that his ACRs of 4 or 5 years shall also be examined. In this case, what will happen, my lord? I am senior, they are not senior, my lord. So they lack the seniority part, my lord. And once, my lord, they will be promoted first as assistant executive engineer, my lord. In the cadre of executive engineer, they will be seniors, my lord. So my contention is that first examine my seniority, then examine my ACR. If my ACR is bad, then don't give me promotion, my lord. Number one. Number two, my lord, that the 3 years service, my lord, subject maximum of 4 years was given for the reason that first, the ABT engineers come under the category of seniority. First, they qualify the seniority rider, my lord. Suppose they may be senior, but their length of service as AE may be less, my lord. So if their length of service as AE is less, my lord, then, my lord, in that case, my lord, that 1/3 service subject to maximum 4 years shall be counted for their eligibility for promotion to the post of assistant executive engineer, my lord. This is my submission, this is my interpretation, my lord, as per all these judgments, my lord. But first they have to satisfy the seniority. Otherwise, my lord, what will happen? The entire situation will not become hodgepodge, my lord. No, it will be disturbed in the executive engineer cadre. Please, my lord, please. Please, my lord. Please, my lord. Please, my lord.
Seniority in the higher post will be determined on the basis of the regulations. What manner? Person who goes first will rank senior. That's the principle.
Please, my lord. Please, my lord.
You must concentrate. They should not get promotion first. You should get the promotion.
Please, my lord. Please, my lord.
Once I get there.
Please, my lord. Please. Please, my lord. Please, my lord.
Then you are considering in 2018,
But what has happened is, during the pendency of these petitions, all of them were attained eligibility. All of them became eligible.
then what you say?
All,
But this is very important.
please,
What you say? See, then, see, you will say all, really all. But at what time 2007 will have become a good case? That you are not concerned with. The implicit is distributed between them. You must tell, according to your calculation of the when we they became and when we they became eligible, we want to know the figures. We also want to know when they were eligible, how many vacancies were there of A and B. Getting the point? And how many people were there with 8 years of service? See, 6 years is the only part. If there are no 8 years available, the intent is to here, I don't have any people, there are vacancies on the higher post. Let me reduce the initial together and make the promotion, and make the promotion. That's the intent.
but what has happened in this case, at that point of time, 2018, no promotions were considered, no promotions were made. It was only in the year 2021 that promotions were made pursuant to interim orders passed in this court. At that time, no promotions happened.
Then I think all those documents will be already.
It is just for
An
consideration.
interim order of stay, my lord.
For consideration for promotion, then there are other steps to be taken as well. But at that time, no promotions as a matter of fact happened.
Yes, yes, my lord. Yes, my lord.
Stay, my lord. The judgment of.
At that point of time, the vacancy portion may have been different, but nothing happened. Only pursuant to the interim orders passed in this case, 2021, everyone became eligible. And then later on, please, if I may just pass on to this one. Arihan.
Carry out this exercise.
18.
17, 18. There any vacancies before 2017? How many vacancies were there? How many persons were there in the areas?
My lord, a copy of the chart may be handed over to you in advance.
But in this case, what has happened is that time has already passed. So promotions at the time of consideration, when we consider, everyone, both of them became eligible. See, at that point of time.
Contesting is, I should be promoted earlier than this. What he's saying is, I am eligible before them, I should go first.
But this exercise happened at the time of consideration of promotion. And at the time, promotions were considered 21. Since both of them.
Exercise you are undertaking in 21.
Was pursuant to interim order passed in this writ, we have granted promotions by a in-charge arrangements to 2007 batch, and some of the members.
It's only an in-charge arrangement, my lord, and they have not considered our claim, though there is an order in my favor. Not about 24 million. 400 million. Yes, my lord, that is the issue, crux of the issue. Crux of the issue is.
400.
Lord, the crux of the issue is, my lord, if the date of eligibility is taken as, my lord, 2018, we would become eligible prior to the direct recruitees, my lord, of 2010. Please, ma'am. In the petition, my lord, there are only, yes. Please, ma'am. Please. Please.
My lord, my seniority, my lord, in seniority, we are direct recruit assistant engineers are more than 450 and 500 rank, my lord. Please,
Yes.
my lord.
5.
And now how much you are at Romania?
Yes.
Please, my lord. No, my lord. They have also.
There are
filed
3
with me.
petitions, my lord. There are 3 petitions. Lord, the first petition, what is your lordship are hearing is the petition filed by the assistant engineers who are direct recruitees. Lord, they approached the court first, my lord, challenging the 2 circulars issued where, my lord, the ABTs were included. Lord, subsequently, the KPTCL issued one more circular excluding our name. We challenged that in WP.
Part of them.
Lord, he is part of us, my lord. Yes, ma'am.
And Karthik is your.
Please, my lord. And my lord, I have to show some judgments of the Supreme Court, my lord, next day.
Lord, I represent. Lord, Naveen Kumar, Renka Prasad, Santosh MR, Mahadev C, and Puttaswamy, I represent. Those are the petitioners, my lord, to whom I had appeared. Yes.
Please,
Only submission is, my lord, these writ petitions were actually premature because as my lord posed a question, we only called for information. And promotions are not granted at all until these petitions were disposed of. So, my lord, 2021.
Only in charge arrangement. My lord,
As on 2021, both of them had eligibility. And these persons are senior to them, the ABT engineers. So on that basis, and since this include order was stayed until further orders, the promotions were given to the directly recruited.
Who are senior according to the.
There's no dispute, the direct recruitees are senior.
Now, the proposition of law. When we, so you are seeing eligibility of which date?
They get eligibility on 29/6/2018. Different dates, lords, but some of them are prior to the directly recruited. Some of them are prior.
So this is your stand. This is your stand.
No, my lord, in counter affidavit, their stand is different.
Calculation, I have to verify. I'll get back to you.
But they have filed appeal against the order of single judge, they have preferred an appeal. Yes, ma'am. Please, my lord.
Because our ground is that the learned single judge has asked us to consider as on 2018. But whereas, at the time of consideration, we cannot consider as per that date because interveningly the directly reputed candidates have also attained eligibility. And then since they are senior to them, they will have to be considered before the. And one more submission was that at the time when the writ petition was heard, since the 2007 batch of promotion was still pending, both of their promotions would be considered after the 2007 batch promotions were considered. Because of promotion in 2021 after interim order of stay. Please, because of all this litigation from that year.
Extremely sorry, my lord. Extremely sorry, my lord. I'm tending unconditional apology, my lord. I forgot to tell you, my lord, your lordship, page 86, very important, my lord. Page 86, my lord. Page 86. Page 86.
Only in-charge promotions have been given, my lord.
This is my mistake, my lord. This is my mistake. Page 86.
Only in-charge basis, my lord, orders have been passed. No officiating promotions have been granted. Lord, that is not correct, my lord, for this reason. For this reason, my lord, in 2018, my lord, when they, in the first circular, when they issued, my lord, they issued only in respect of 2010 batch.
So you were eligible.
Yes. Is not correct, my lord. Let him place the material before the.
My lord.
Lord, they have not given any promotion after 2019 on officiating basis. All arrangements are made only on in-charge basis.
That I stand in-charge basis because of pending litigation.
Yes.
If 2007 who are senior to you, got an in-charge promotion in 21, can you have a better right than them?
Yes, my lord. For this reason, for this reason, the council appearance for KPTCL, my lord, may not be knowing that there was no officer of 2007 batch was available as on the date when the circular was issued for promotion, considering our claim. That is my specific instruction. So, 2007 batch, they have already granted promotion. Only in 2010 was the batch which they sought to grant promotion by issuing a first circular, and subsequently they came to know that they have to consider our claim first for the reason that we have become eligible earlier to those persons.
My lord,
yes,
my lord, I forgot.
Bring the statistics.
I forgot to point out one thing, my lord, which is very crucial, my lord. Page 86, my lord. Page 86, my lord. It starts from page, I had shown, my lord, but I had not given him first page. It starts from page 83, 86, my lord. Column 8, my lord, assistant executive engineer should have completed 5 years of service as assistant engineer. It came in on, my lord, 27th July 2016, my lord. My date of appointment is, my lord, 29/6/2010. So I became eligible for promotion to the post of assistant executive engineer on 29/6/2015, my lord. At that time, this, my lord, regulation was prevailing, my lord. Because it was amended in 27th July, my lord.
To me also.
No, not another dimension. Please. 2016, 15, my lord, 2015, because when this
I would become
criteria was changed, at that time I was eligible. Please, my lord. Please, my lord. Yes.
Not available.
Please, my lord. And I had completed 5 years, my lord.
But there were seniors who had completed more than 5 years.
At the time of consideration, so that time you have to see the rule existing at the time of consideration. So this 5 years may not be applicable at that time, 2008.
See, there is situation, there are no vacancies. It will be eligible, if you don't get promoted, there are no vacancies. By the time you go to that stage, you have become agencies.
Otherwise, we were eligible in 2015, my lord. Please.
And there were seniors above him, my lord, who were eligible, my lord, and their claim.
Is
not correct.
That fact, so this question as to that relevant date may not be relevant because promotions were given only 2021, not at that historical time.
We want to know how many instructions, how many 2007 people have been given.
Please. How we could be. Please.
60 people.
60 people.
That's in charge arrangement. No, let me check on that, my lord.
Eighteenth, my lord.
May I request for the week after that?
18th, my lord, 18th suits me, my lord.
May I request for 27?
27. 27 is Saturday.
18th, 18th.
May I request for 16th, 18th and 19th?
Then, my lord, 23rd, my lord.
Please.
26/7.
Please, ma'am. 2:30, ma'am.
Your lordship may fix the time, my lord, since I am coming from Delhi.
Please.
30.
Day.
Kindly make it 30, my lord, 30. 30, 30th. No, 30 is
30th is Tuesday, ma'am.
Tuesday, my lord.
Please.
2:30, my lord, or
Please.
List number 2, serial number 1, Shri G.S. Subara. Serial number 1. Serial number 2, Shri Sanjeev B.L. Three. Serial number 3, Shri Ajay J.N. Serial number 4, government advocate.
Paper state, madam. For the state, my lord. We post our next Monday, my lord. Then the AG will appear. I will brief the matter. Monday or Tuesday it may be posted. Monday or Tuesday, my lord.